Okay, just so everyone is aware, the video is streaming out live on YouTube.
And Your Honor, I see that my colleague has joined us.
Yes, sir. I see Mr. Abramson.
Good morning, Your Honor.
Good morning. So are there any additional attorneys or individuals that we are waiting on? I see Dr. Ocaranza also is on.
Good morning.
That's correct, Your Honor.
Good morning,
He's
Dr.
our
Ocaranza.
only witness today.
Okay. And with respect to Mr. Dower, is there anybody else on your side that we're waiting on?
No, Your Honor, from our perspective, we're ready to begin when you are.
Okay, just give me one quick minute.
And Ms. Chavez, sometimes I've been known to be a fast talker. If I ever start talking too quickly for you, you interrupt me and you stop me because I don't want to make your job difficult. So I'm apologize in advance if that happens.
I'll probably only interrupt if you all talk over each other or don't give enough time between people.
Okay, so we are now streaming live on YouTube. It is 9:01 now. For anybody watching this on YouTube, please be advised that recording of this proceeding is not allowed unless you have obtained permission from the court. Just so the parties know, one of the local TV stations did reach out and request permission to record the proceedings, and I did grant them that permission. That was KVIA Channel 7. I have not received any requests from any additional news stations to record the proceedings, but to the extent I receive requests from any of the other local broadcast companies, I intend to grant them the same permission that I granted to KVIA. But again, I repeat, with respect to anybody who has not obtained specific permission from the court, a recording of these proceedings is not allowed. Before I call the case, do we have any preliminary matters that we need to take up?
I have one question, Your Honor. But we noticed we're not able to, there's not an option for us to share the screen. And so I don't know if that's something that you need to enable for us to do that. But we had planned on sharing our screen so that we could share the exhibits that we intend to introduce.
Absolutely, Mr. Lasley, I will allow you to share the screen. I think.
So if you could do it for Ms. Anchando, she's going to sort of handle our exhibits.
Perfect, that's what I'll do. And then with respect to Mr. Dower, if when the time comes, if you need me to share the screen, please let me know and I will allow you to share your screen.
Thank you, Your Honor.
Thanks, Judge.
And then let me see, Ms. Nicole Anchondo, let me give you screen sharing.
Good morning, Your Honor. Thank you.
How's that, Ms. Anchondo? Is it allowing you now?
I am still not seeing the option to share. Yes, I see it now, Your Honor. Thank you.
Okay, perfect. Thank you. So if there's nothing else, then I will go ahead and call the case. This is the City of El Paso plaintiff versus Greg Abbott in his official capacity as Governor of Texas defendant. Cause number 2021 DCV 2805. We are scheduled this morning on a hearing regarding the City of El Paso's request for temporary injunction. Can I please have announcements of council? And if you could please introduce everybody that is with you on this proceeding.
Thank you, Your Honor. Senior Assistant City Attorney Manny Aramboa here on behalf of the city. Along with me, Your Honor, are the City Attorney Carla Neiman, Senior Assistant City Attorney Kyle Lasley, and Assistant City Attorneys Nicole Anchondo, Matthew Engelbaum, and Evan Reed. For the purposes of this hearing, we only anticipate that the only individuals who will probably speak are myself, Mr. Lasley, and possibly Ms. Neiman. Thank you. We're ready to proceed, Your Honor.
Thank you, Mr. Arambola. And Mr. Dower.
Yes, Your Honor. Benjamin Dower and my colleague, Daniel Abramson, for the defendant, Greg Abbott, in his official capacity. Your Honor, there is one other matter I wanted to bring to the court's attention before we proceed, which is the defendants filed a plea to the jurisdiction on August 30th, which is almost in my mind a sort of like a cross motion with the city's application for temporary injunction. The Governor Abbott is arguing that the court lacks subject matter jurisdiction over the case, but the issues are deeply intermeshed with the substantial likelihood of success on the merits from the city. And what we would respectfully request, Your Honor, is that because the order granting a temporary injunction is an exercise of the court's subject matter jurisdiction, the court can't grant the temporary injunction without necessarily saying, you know, I have decided that I have jurisdiction to do that. And so there's a fairly decent amount of case law that says to grant a temporary injunction is to deny a plea to the jurisdiction. And so we would ask the court to take these up together. If that means that the city needs additional time to submit a response, we'd be happy to do that. But because an order granting a temporary injunction is an exercise of jurisdiction, it would be a denial of the plea to the jurisdiction to grant the temporary injunction. If the court wants to just issue an order denying it, if the court is inclined to grant the temporary injunction, we could do it that way. But the two issues are sort of inextricably intertwined. And so I would just ask the court to take them up at the same time.
And Mr. Arambola, the city's position.
Well, Your Honor, the motion was filed late Monday afternoon. I will obviously concede that the Attorney General's office has met the bare minimum legal requirements for notice and a posting for a notice. My understanding is that the court only set this matter for a hearing on our temporary injunction. And I did a little bit of work on this, and my understanding is that there's absolutely there's no jurisdictional requirement that the plea to the jurisdiction be heard at the same time. Matter of fact, as I'm sure the court is quite aware, there's numerous times when a plea to the jurisdiction is heard after that, because a plea to the jurisdiction cannot be waived. So we leave it to the court's better judgment as to whether or not it wants to hear this matter. I don't know that the court had the opportunity to read it. I've obviously read the Attorney General's plea to the jurisdiction. I'm at least somewhat prepared to argue it, but I believe that the issues themselves can and certainly should be resolved at a different time. But once again, that is the court's, I think that's up just simply to the court's decision whether or not to do so. I will point out that the pleas to the jurisdiction, as Mr. Dower points out, can be summarily dismissed if the court decides on its own motion that, in fact, it doesn't have any merit with respect to the claims being made here. I would suspect that some of those issues may be addressed with the elements of a plea of a temporary injunction. But once again, I'm not aware of any jurisdictional bar to having this heard prior to the plea to the jurisdiction.
Your Honor, can I show you some authority real quick so that Your Honor knows I'm not making it up out of whole cloth?
And yes, sir, Mr. Dower, Mr. Arambula, you are correct that this matter was only set for the temporary injunction hearing. I know the Attorney General did file their plea to the jurisdiction, and along with that, they submitted a notice of hearing, which was not submitted to the court, and that was sent out. So technically, it is only set here for the temporary injunction hearing. With that said, I don't know if the city, and I'll give you some time, Mr. Dower. I'm not forgetting that you had some additional comments, but with that in mind, I don't know if the city would like to file written response to the plea to the jurisdiction, or if the city just intends to argue its position, or what the city would like to do. And let me hear from Mr. Dower, and then I'll come back to you, Mr. Arambula.
Your Honor, I'm a visual learner. Can I put up a document that has some case sites and quotes for the court? Would that be okay?
Yes, sir.
Okay. I don't want to be too presumptive. So here's some legal authority that supports the proposition. So the basic idea is that the court can't reach the merits of a case without exercising subject matter jurisdiction, and a temporary injunction is an exercise of equity jurisdiction. And so as one, for example, the Fifth Court of Appeals put it, the grant of the injunctive relief serves as an implicit denial of the plea to the jurisdiction. And here's another case from Beaumont. By entering the temporary injunction order, the trial court implicitly denied the defendant's plea to the jurisdiction. And so, but I understand the importance of notice, and I understand the importance of giving the city an opportunity to respond. And I don't believe in trial by ambush, and that's not how I practice law. So, if the court wanted to give the city time to respond, I do think that the issues are basically it's a Venn diagram that's almost one circle in terms of, the briefing on the plea and the briefing on the substantial likelihood of success on the merits. And if the court is inclined to just grant the temporary injunction and thereby has determined that the court has subject matter jurisdiction, then that's certainly in the court's discretion. And then at that point, it would be a matter of just issuing an order denying the plea, and the two can go up together in lockstep and be decided at the same time by the appellate court, since they're both subject to interlocutory appeal anyways. Part of this is just trying to avoid two appeals that have so much overlap that are out of sync going on simultaneously. And so just trying to be efficient on that point as well.
And Mr. Dower, with respect to your statement that you are not opposed to giving the city additional time to respond to your plea to the jurisdiction, I assume that also includes your agreement to extend what is currently in place until we come back to court, correct?
Well, unfortunately, I probably don't have authority from my client to do that. So I probably couldn't agree to that right now. I don't know how much more time the city would require to file a written brief. I don't know whether they could do that by tomorrow so that we could get this resolved before the weekend. But I don't think I have authority from the governor's office to agree to any extensions of the TRO. And I recognize that may make what I just said less persuasive or less palatable to the city. But there it is.
Well, I think it's implicit in your request and your statements that you are agreeing to that. I understand you're saying you need to get a grant of authority, but I assume that by being present here, representing Governor Abbott, that you have authority to act for him here in this court today. Otherwise, that I would request that you, I guess that we reconvene and that we have this hearing with individuals who have authority to act on behalf of the defendants.
Well, then, Your Honor, I guess since I can't agree to extend the TRO, then I guess I will. If Your Honor feels like that's linked, then I guess I have to rescind what I said and say the two issues have to be resolved at the same time. And that's all I can say.
Thank you, Mr. Dower. Mr. Arambula?
Well, Your Honor, I think the issue of the TRO, as the court is well aware, it extended the TRO to this date for the purposes of having heard it, because the TRO was going to expire by its very own terms on Tuesday. So the question was, what do we do with respect to this hearing? And what we were supposed to have is the actual, the hearing today strictly on that issue. Now, when the Attorney General's office filed a PTJ, unless I'm very much mistaken, I think that the TRO statute only permits one extension without agreement. Without that agreement, we're stuck with what's going on here today. And be that as it may, I think as a matter by operation of law, I think the temporary restraining order today actually will terminate today. So the court, I think, has to make a decision on the issue of both the temporary injunction as well as that. So if that's the status of the situation, well, then we will argue the PTJ today. I don't know that we'll get a response, but I feel certain that the status of this case, as well as the law, is on our side. So if the court wants to, I mean, without the agreement to extend, it will have to make a decision today. And as Mr. Dower correctly states, if the court simply grants the preliminary injunction, it impliedly is approving of the court's, the court is approving of its jurisdiction over this. I think they are intertwined. I really don't think the issues are that difficult. This is really more about just the way the situation broke down. Had we considered that this might have been an issue when we had a brief discussion about this, we would have broached the subject of having the court extend the TRO for 2 weeks so that it could then comfortably make this decision. But here we are. So that being said, Judge, we will argue the plea to the jurisdiction as well as the request for the temporary injunction.
Could I interject one thing here, Judge?
Yes, sir, Mr. Leslie.
There's just because that case says that the granting of a TRO is an implicit denial of a plea to the jurisdiction doesn't mean that you have to hear a plea to the jurisdiction before or at the same time as you hear the TRO. Courts routinely hold pleas to the jurisdiction in abeyance until they conduct discovery, until they give litigants an opportunity to replead. There are all kinds of scenarios in which a plea to the jurisdiction doesn't have to be ruled on at any particular time by the court. So the filing of a plea to jurisdiction in this case is not a legal impediment to the court going forward with the hearing on the temporary injunction and making a ruling on that. And even though it may be an implied denial, there's no requirement that the court rule on the plea to the jurisdiction at the same time the court rules on the TRO. Is it more convenient for the Attorney General's office with respect to their ability to take, 2 issues up on appeal, on an interlocutory appeal? Maybe, but that doesn't mean that it's required by the court.
Thank you, Mr.
I won't belabor the point. I know we want to get on. I will just say that if the court grants the temporary injunction, we will file a notice of appeal that includes the appeal of the plea to the jurisdiction as it being implicitly denied. And we feel very confident in our legal authority to do that. So all I'm really doing is wanting to be transparent about that and make sure that we argue, we get full arguments before the court, before the court issues a ruling one way or the other. And I'll leave it at that and appreciate the court's time on this issue.
So with respect to the plea to the jurisdiction, again, we're not set for a hearing on that matter today. It was not properly set before the court. I'll allow the parties to briefly address that issue, but I'm not necessarily going to consider the plea to the jurisdiction today. If I change my mind and when I make my ruling on the temporary injunction, I believe that I'm ready to rule one way or the other with respect to the plea to the jurisdiction. I will let you know that, but I will let you address the plea to the jurisdiction with the understanding that, again, we are not set for that. We were not, it was not properly noticed or set for a hearing today. I do understand, Mr. Dower, that your office did prepare a notice of hearing and send it to the city attorney's office, but that notice of hearing was never presented to the court, or was permission requested from the court to set that matter for a hearing today. So with that in mind, I don't believe that it's necessarily properly before the court. And but with that said, we'll go ahead. Tell me what you have on that, Mr. Dower.
You know, Your Honor, I think I've said my piece. I appreciate where the court is coming from, and I'll just say, you know, we've had I think 9 temporary injunction hearings on these GA 38 cases in a period of about 2.5 weeks, and so I apologize if we dropped the ball on an administrative matter. It's been quite the deluge to keep up with it all. But all I can say, Your Honor, is that if the court is going to grant the temporary injunction, it is decided that it has jurisdiction to do so. And frankly, you know, the arguments I would make on the plea are going to be the exact same arguments that we would make in the response to the application for temporary injunction. I mean, we put it in one filing for a reason, because they're so thoroughly intermeshed that there's no real difference between the two. And so I appreciate where the court is coming from as far as settings, but I believe my friend on the other side has said that they're prepared to argue it and argue their case. And so I would just ask the court to make explicit that which it's going to do implicitly in terms of if the court is inclined to grant the temporary injunction.
And one last thing with respect to giving the city time to respond, Mr. Dower. If the city was going to request time to respond, my plan was to most likely set it on Tuesday or Wednesday of next week. It was not going to be set tomorrow, but it was going to be set quickly for Tuesday or Wednesday. So with that in mind, I don't know if that changes what you're able to do, what you're willing to do. If it doesn't, I understand.
Well, if Your Honor was going to defer ruling on the temporary injunction till then that wouldn't be an issue. But I can understand that why the court would not be inclined to do that. And so yeah, that's all I have, Your Honor.
And so that is what I'm asking. I mean that.
So I guess
the reason to reset it to Tuesday or Wednesday would be so that I could hear your plea to the jurisdiction, and then right after that, go into the hearing on the temporary injunction. That would be the only reason to reset it to Tuesday or Wednesday. Otherwise, we might as well go forward here today.
Right. And I don't believe, I think Mr. Arambula is probably correct that we can't extend the TRO. So if the city feels that it's very important to get the temporary injunction ruling now, then the city probably will not agree to delay that ruling until Tuesday. But I don't want to speak for anyone else. That would just be my expectation. But I'll let the city speak for itself.
Well, Your Honor, I think the TRO statute doesn't permit a third extension without the agreement of both parties. And what I'm hearing is that agreement is not forthcoming. So I think the court has to rule on the temporary injunction today. It's my belief, as Mr. Lasley stated, that the court still can actually take up the issue of the plea to the jurisdiction next Tuesday. But certainly, just as a result of the way that this has worked out, I mean, I think the city certainly wants to maintain the mass mandates as it stands, which after the 8th Court of Appeals just limits it obviously to schools and city-owned properties and with city-owned and operated properties. So we want to maintain that. In order for that to happen between now and then, there has to be an active order. So to that extent, I think the court is bound to do that today. like once again, had we anticipated or had a discussion about this probable possibility, we would have simply asked the court to extend until, for an additional 2 weeks. And when we had a brief discussion about this, the PTJ hadn't been broached, and it wasn't broached. I'm not arguing that the Attorney General's office operated in bad faith. I'm just simply pointing out that the way that this actually happened was we agreed to extend it to Thursday, and then the PTJ was filed. And so with that, we're somewhat in, as the saying goes, on God's little acre, west of the rock and east of the hard place. So, but I think the court would be well empowered to file their, if the court agrees with the city's argument, certainly the court can make the ruling, the court can set it, and the Attorney General's office can certainly take any legal action it feels appropriate between now and then.
Okay, thank you, Mr. Arambula. Thank you, Mr. Dower. What I'm going to go ahead and do is allow you to go forward with the hearing on the temporary injunction. Since Mr. Dower, you've indicated that the issues are, and both of you have indicated that the issues are intertwined and very similar. I may consider your arguments with respect to your plea to the jurisdiction when it comes time for you to make your arguments, and we'll see. And if I feel like we need another hearing on the plea to the jurisdiction, I will set that for sometime next week, and I'll give you the dates on that if it comes to that. On the other hand, of course, if I deny your plea to the jurisdiction today, then we won't need to do that. And with that, Mr. Arambula, are you ready to proceed?
We are, Your Honor. I guess consistent with our discussion today, Your Honor, what we will be presenting today is, at the very least, the outlines and we will directly address the issues of the elements of that would prove the court's authority to grant a temporary injunction. So those are three separate elements: a cause of action, a probable right to relief, and imminent injury in the absence of the grant of a temporary injunction. At least some of that evidence, Your Honor, is going to come from one of our witnesses, Dr. Hector I. Ocarranza, the city and county's local health authority. The rest of the argument, quite frankly, is actually based on an interpretation of law and also the pleadings and the evidence that will be submitted to the court. I think in our communications this morning, our understanding is that we probably have an agreement to a number of the exhibits. I think before we proceed with the actual presentation of evidence, I'm pretty confident we can agree to almost all of the evidence that will be submitted before the court. I think there's only one that is actually even moderately contested. I'll let Mr. Dower speak to that. But what we will be doing, Your Honor, is we will be presenting our witness. And at the end of that, assuming the usual procedure for argument, I'll be presenting my argument based on the evidence that's been presented. Then Mr. Dower will certainly present his argument, and then we'll have a final rebuttal with respect to any arguments that are made. And I suspect that this will probably be a fluid hearing, and the court would let us know if it wants to hear more on the issue of the plea to the jurisdiction, if it feels inclined to do so. At least that's what I anticipate we will do, but we'll obviously take the court's guidance on these issues.
Yes, sir, Mr. Arambula. If you have exhibits that are agreed upon, we can go ahead and admit them at the beginning of the hearing, and that would probably expedite things.
Yes, sir.
I'll take care of that. I'll take care of that, Judge, when I'm during the examination, Dr. Ocarranza. We only have 4 exhibits. The exhibit D is the exhibit that we don't have an agreement on, and it's got like 8 pages. But the other exhibits, as I go through the examination, I'll introduce them, and I think it'll just be easier that way. Okay,
that's fine, Mr. Lasley.
Thank you.
It's your case. I'll let you present it how you think is best. Mr. Dower, anything?
No, Your Honor. I agree with everything that my colleagues on the other side have said. And Mr. Abramson will be doing the cross-examination as well as any evidentiary issues that might arise. So I will defer to him as we proceed.
Okay. Thank you, Mr. Dower. And Arambula, I took that to be, I guess, your version of opening, or do you want to make an additional opening statement?
Yeah, just very briefly, Your Honor. The evidence that we're going to present, Your Honor, with the testimony of Dr. O. Carranza is going to be the issue. It actually covers at least partially all of the evidence that we'll be presenting to this court with respect to the city's right to a temporary injunction. Number one would be a cause of action. I think it'll become readily apparent to the court based on the not only the pleadings already before the court, but the evidence that's going to be submitted to the court that there is a viable cause of action. Secondly, a probable right to relief. And then lastly, imminent injury in the absence of a temporary injunction. That will be the lion's share of the testimony offered by Dr. O. Carranza. And at the time that, instead of simply reiterating everything twice, both at the beginning and at the end, I will reserve the arguments that for my initial closing based on the evidence presented and also the affidavits. Thank you, Your Honor.
Thank you, Mr. Arambula. Mr. Dower or Mr. Abrams?
Yeah, I'll also largely defer any sort of argument to after we've finished the evidentiary portion. The only thing I'll say is that this case really comes down to a question of law, not really so much fact. It's more of a legal question about who has authority under the Texas Disaster Act between the governor and a county or a local public health official for a county. And so from our perspective, most of this evidentiary presentation is not really relevant to the single question before the court, but we'll talk more about the law after we get through the presentation.
Thank you. And with that, Mr. Arambula, you may proceed.
Thank you, Your Honor. Mr. Lasley will be handling Dr. O. Carranza's testimony.
Okay.
And just so that, just for procedural, Your Honor, I'm assuming that you want everybody who is not actually speaking at the time to mute their cameras and turn off their cameras and mute their microphone while this is going?
Yes, sir. That'll make it easier as far as to see who's on and who's not.
Thank you, Your Honor. Will do.
Okay, Mr. Lasley, you may proceed.
Thank you, Your Honor. We called Dr. Hector O. Carranza.
Okay. Dr. O. Carranza, will you please raise your right hand? Do you swear that the testimony you're about to provide in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, Dr. O. Carranza. You may lower your hand. Mr. Lasley, you may proceed.
Thank you, Your Honor. Dr. O. Carranza, would you please introduce yourself to the court and to Mr. Abramson and Mr. Dower from the AG's office?
Yes, sir. I'm Dr. Hector Carranza, the local public health authority for the city and county of El Paso.
So you touched on a little bit there about what your job is as the local health authority, but do you have your own practice here in El Paso?
Yes, sir. I have an active license to practice medicine in the state of Texas, and I have an active license to practice medicine in the state of New Mexico as well.
What's the nature of your current medical practice?
I'm a general pediatrician, board certified since 1999, and I have been board certified pediatrician since then.
Would you describe for the court, please, your education?
Yes, I graduated from medical school in 1993, and then I proceeded to have my general pediatrics residency program at Texas Tech University Health Sciences Center in El Paso, which I graduated in 1999. Since then, I became board certified pediatrician. I hold an active license to practice medicine in the state of Texas and also in the state of New Mexico as well.
And then, do you have a master's in public health?
Yes, sir. I have my master's in public health from the University of Texas School of Public Health, which I received the diploma in 2014 and has been practicing also public health. I've been appointed the local health authority for over 13 years as well.
Are you a member of any other professional associations?
Yes, sir. I'm a member of the Texas Medical Association, El Paso County Medical Society, the New Mexico Medical Society, the Texas Pediatric Society. I have clinical appointments with Texas Tech University Health Sciences Center. I've held clinical appointments at the University of New Mexico as well. I assist and train the new physicians, nurse practitioners, physician assistants as well.
Ms. Anchondo, would you please share your screen and share City's Exhibit A? Dr. Ocaranza, on the screen there is the City's Exhibit A. I'm going to ask you, do you recognize that?
Yes, sir. That is my current curriculum vitae.
Your Honor, we'd offer Exhibit A.
No objection, Your Honor.
Exhibit A is admitted.
Your Honor, at this time, we would offer Dr. Ocaranza as a medical expert in the area of public health and infectious and communicable disease. Would you please unshare your screen, Ms. Anchondo?
Your Honor, we would object just in the sense that Dr. Ocaranza's medical experiences as a pediatrician, what I anticipate is that counsel may attempt to proffer him as an expert witness on masks or epidemiology, which is not his background. So I don't think a proper foundation has been laid to tender him as an expert on those matters. To the extent that counsel is going to do that, we would object.
Mr. Lasley.
Your Honor, he has a master's in public health from the University of Texas at the Houston School of Public Health. He has been the local health authority in El Paso, in the city of El Paso and county of El Paso for the past 13 years. I think he's qualified to give opinions as a local health authority whose responsibility by statute is to protect the community from the very things that Mr. Abramson just identified.
Okay, thank you, Mr. Lasley. Mr. Abramson, your objection is overruled, and you may proceed, Mr. Lasley.
Mr. Ocaranza, or Dr. Ocaranza, would you please describe for the court your duties as a local health authority?
Yes, sir. As a local health authority, it is my duty under the Texas law to collect information, data, and provide it to the Commissioner of Health at the Department of State Health Services. It is also my duty to protect my community against communicable diseases and other threats to public health. In that regards, it is also my duty to apply the laws to public health in our community as well.
And what are some of the tools available to you as the local health authority to achieve those duties that you just described?
The tools that I have available as public health interventions are considered, among others, the mask and the wearing of the mask. Also, some non-pharmacological interventions, such as the prevention strategies. We do have also pharmacological interventions, such as a vaccination as a preventive tool to stop and reduce the spread of a communicable disease as well.
As the local health authority, have you had a role in the response of our community, the city and county of El Paso, to the COVID-19 pandemic?
Yes, sir. At the beginning of the pandemic, I took the leading role in the response to the COVID-19 to protect my community as the statute and the Texas law. It is my duty to protect my community, to preserve health and life in my community, and also to do everything at my disposition to carry out my duties and protect the health and well-being of my community.
Ms. Anchondo, would you please share your screen and share City Exhibit B? Dr. Ocaranza, do you recognize what's shown there is City's Exhibit B?
Yes, sir. This is my mask mandate that I issued on August 17th, 2021, in which we mandate every resident in the community older than 2 years of age to wear a mask while indoors. That will align also to the recommendation from the Centers for Disease Control and Prevention, the leading federal authority for public health.
Ms. Anchondo, would you please share City's Exhibit C? Can you reduce that one to where, oh, perfect. Thank you. Doctor,
Just up any old piece of fur, you know. If the job ain't 100% right, you don't pay. That's the story.
So Dr. Ocaranza, do you recognize City's Exhibit C?
Yes, sir. This is an amended mask mandate issued on August 27, 2021 to comply with the appellate court in regards to the mask mandate that it was going to be only applicable to the school districts and also to city government buildings.
Your Honor, we'd offer City Exhibits B and C.
Mr. Abramson?
No objection, Your Honor.
Ms. Anchondo, would you unshare your screen, please? Thank you.
Use Exhibit B and C are admitted.
Thank you, Your Honor. Dr. Ocaranza, would you please tell the court what prompted you to consider and ultimately enter the mask mandate that's indicated in City's Exhibits B and C?
Yes, sir. The data that we collect, it was analyzed and we saw a very concerning upward surge of positive cases, which in turn also led to an increase in hospitalizations. We saw that the number of cases had increased weekly of about 35 to 45% on the positive cases. We have a community that is very vulnerable, and therefore we were expecting a larger amount of hospitalizations due to the COVID-19. We know that the COVID-19 virus is very infectious, and now we have the proof that we have the Delta variant in our community, which has proven to be 4 to 5 times more infectious than the original virus. Our community saw the upward trend and surge of hospitalizations in approximately 75% in the last month compared to the previous one. And therefore, those very concerning indicators prompted me to issue the mask mandate.
Dr. Ocaranza, have you seen City's Exhibit D?
Yes, I have seen the City's Exhibit D.
Okay, and so City's Exhibit D has 8 pages, D1 through D8, is that correct?
That is correct, sir.
So are the facts and data that are represented in Exhibits D1 through D8 the type of information that is relied upon by experts in the field of public health, informing opinions or inferences about that subject?
Yes, sir.
And do the facts and data represented in these exhibits form the basis of much of your testimony here today?
Yes, sir.
And is this data required to be reported to the local health authority?
That is correct, sir.
And are you the authority responsible for the collection and reporting of this data?
That is correct, sir.
And is the data public information?
Yes, sir.
Did you create the exhibits in D1 through D8?
Yes, sir.
And do these exhibits accurately reflect the data that's reported on this subject?
Yes, sir.
Your Honor, at this time, we would offer City's Exhibits D1 through D8.
Mr. Abramson?
Your Honor, given the foundation that's been laid, no objection.
All right. City's Exhibit D is admitted.
Okay. Ms. Anchondo, would you please share your screen with Exhibit D2? That's D1. There you go. And is the court able to see the screen?
Yes, I am.
Okay. Dr. Ocaranza, would you please describe for the court, you mentioned in your answer to the last question that you saw an increase in the number of of cases or infections here in our community. And could you describe for the court what's demonstrated in the city's exhibit D2?
Yes, sir. What we see is from CDC week number 26, we can see an upward trend that is very concerning. This line, the blue line, represents the number of cases that we see in El Paso County by the number of cases that we have positive for COVID-19. So since CDC week number 26, we can see how it has a sharp upward trend on the number of positive cases.
So on cities D2, on the horizontal axis there at the bottom of the chart, we've got the year, and then each I guess segment indicates a number, and they're sequential. Would you describe for the court what that is?
Yes, sir. What the horizontal axis shows, as you mentioned, is the year and also what is called a CDC week. The Center for Disease Control establishes the whole year in weeks in which it ends on a Saturday and the new week starts on a Sunday. The city exhibit D1 shows the date that it ends on a CDC week, and that's how it's represented by numbers, and that's how epidemiological data is presented to reflect what has been happening during those weeks.
Ms. Anchanda, would you please share city's exhibit D1? Okay, so would you explain to the court further, please, using city's exhibit D1, what those indications are on the horizontal axis of these exhibits?
Yes, the CDC week number 26, it ends on 7/3/2021. CDC week number 27 ends on 7/10/2021, and so on and so forth progressively every week. So therefore, we label the horizontal or x-axis as the year and the CDC week.
So essentially, those are date references with respect to the data that's being graphed on the chart. Is that correct?
That is correct, sir.
And city's exhibit D1 is essentially the legend for that date reference.
That is correct, sir.
Okay. So Ms. Anchanda, would you please share exhibit D3? And would you explain to the court, Dr. Ocaranza, what you demonstrate here in exhibit D3?
Yes, sir. What we're demonstrating here in exhibit D3 is a closer look at what the number of positive cases have been. We divide the positive cases by age groups, 0 to 17 represented by the green line, 18 to 30 represented by the orange line, 31 to 45 represented by gray line, 46 to 65 in the yellow line, and older than 66 as a blue line. As we can see, mentioned before on the number of positive cases, from the CDC week number 26, we can see how the number of positive cases has increased. Initially, it was predominantly in the young adults between 18 to 45 years of age, but by CDC week number 21-31, then we saw a sharp exponential increase on the pediatric cases represented by the green line from 0 to 17 years of age. And now we can see that also has been decreasing on CDC week number 34.
Okay, we'll get to that, okay? Ms. Anchanda, would you share exhibit D4, please? Now, you previously spoke about it, not just the increase in the number of positive cases, but you also spoke to an increase in hospitalizations. Is that correct?
That is correct, sir.
And would you describe for the court what is shown in exhibit D4?
Yes, what it is shown on exhibit D4 is the line of hospitalizations. This line is represented from the beginning of the year, CDC week number 5, which is approximately in February. But what we can see is that in the summer, we had a low number of hospitalizations, which changed very rapidly. By CDC week number 26, we see an increased sharp trend that is very concerning on the hospitalizations that we're seeing.
And then are you seeing a trend with respect to different segments of our population that are being hospitalized? Ms. Anchanda, would you share Exhibit D5, please?
Yes, sir. What we can see here is a little closer look on the hospitalizations. What we can see, and it's represented by these bars, is the percentage of people hospitalized by age group. What we can see on the trend is that the hospitalizations are increasing in the older adults, 46 to 65, but also in the senior citizens, which are the 66 years of age and older. We see that it has changed over time, and we see a large increase, which occupies the large percentage of those hospitalizations.
And then have you also noted a trend in the increase or an increase in hospitalizations among people who are vaccinated?
That is correct. We're seeing that even with
Ms. Anchanda, before he answers, would you please share? There you go. Thank you very much. I'm sorry to interrupt you, doctor. Please go ahead.
No, thank you, sir. And this graph represents the hospitalization on people that have been fully vaccinated. We call it breakthrough hospitalization because these people have been fully immunized. They have been protected with the vaccine that has shown to be very effective. But unfortunately, our community is extremely vulnerable. And even with the protection that the vaccine confers, we see the hospitalization, and it is represented by the vast majority of those hospitalizations in population that is fully immunized, is on those that are 66 years of age and older. What is and worth mentioning also is that this breakthrough hospitalization is happening also in the age group of 46 to 65 years of age. That is also the adults that have been getting hospitalized at an increased rate, even though they're fully protected.
And then is there a correlation between the number of positive cases and then hospitalizations that you will see out of that number?
Yes, what we know from the data that we collect in our community is that there is approximately 10 to 20% hospitalizations for when out of the positive cases that we have. So that is our hospitalization rate that we have in our city. We expect that every time that we...
Then is there another correlation between the individuals or the people that are hospitalized with the virus and then the people who might ultimately die from the virus?
Yes, we know also that the people that get infected with the virus, 2% of those people are going to die from complications of the virus. People that also end up in the hospital are more likely to pass away from complications of COVID-19. And those complications arise more frequently in people that have comorbidities or pre-existing medical conditions, particularly those that are extremely common in our community, such as diabetes, high blood pressure. And in many of our community, approximately 1/3 of our community do not have a medical insurance to care for those conditions, which in turn they are not very well controlled, making them a lot more susceptible to have complications and die from COVID-19.
So you're getting a little bit ahead of me, but so are you essentially describing characteristics of our population here in El Paso that make it even more concerning, these increases in infections and hospitalizations that you've seen?
Yes, sir. That's what I am describing. The very unique characteristics of my community, which might be different from other communities, but our community has a very particular composition that also makes it vulnerable to COVID-19. Our community is composed of approximately 85% Hispanics. Hispanics in the United States occupy second prevalence of diabetes and high blood pressure. And as well as mentioned before, 1/3 of our community have no means of caring for those chronic conditions. Therefore, it is extremely likely that those conditions are not very well controlled, making them more susceptible to the complications of COVID-19.
And what percentage of people who have died in El Paso from COVID-19 have had these pre-existing or underlying conditions?
98% of the people that have passed away from complications of COVID-19 have comorbidities or pre-existing medical conditions in our community.
So, and when you compare the number of deaths in our community from COVID-19 to other communities around the state? How do we compare?
We rank number 1 in deaths compared to other metropolitan areas in deaths due to COVID-19.
So how many people, based on, I guess, CDC guidelines with respect to eligibility for vaccination, how many people in our community are eligible for a vaccination?
Based on the population estimates, and it is also published by the Department of State Health Services, approximately 688,000 people are eligible to receive the vaccination that are 12 years of age and older.
Your Honor, very briefly, at this point, I would object to relevance for 2 reasons. One, this is a question of who has the authority here, the governor or Dr. Ocarranza, but also this is regarding a mask mandate. In terms of this line of questioning on vaccination, I would object to relevance.
Sustained.
Okay, so how many people are unvaccinated?
Again, same objection, Your Honor. We object to relevance.
Your Honor, if I may,
Yes, sir.
the relevance, I think, will be clear to His Honor once Dr. Ocarranza answers the question. But we still have a certain percentage of our population that is unvaccinated, and I believe the testimony will indicate that makes them highly susceptible to the Delta variant, which is in our community, and therefore that creates a risk for everybody else in our community with respect to the spread of this particular variant in our community.
Okay. With respect to that objection, it's overruled, Mr. Abramson. You may continue, Mr. Leslie.
So, Doctor, would you please tell the court how many people approximately are unvaccinated in our community?
Well, we have approximately 30% of our population eligible to receive the vaccine unvaccinated. That means out of the 688,000 people that are eligible to receive, we have about 160,000 people that have not received the vaccination at this time.
So let's talk just for a second about the Delta variant. All right. So is the Delta variant present in our community?
Yes, sir. It has been present, and we had identified the Delta variant since July 2021.
To what degree is it present in our community?
It has it is the most prevalent variant that is attacking our community, and also across the state.
So in our community, when you say it's the most prevalent, 95% of the cases, is that fair?
That could be considered fair.
All right. And so describe to the court what is concerning about the Delta variant as compared to the previous variants that we've had in our community?
The concerning fact about the Delta variant is that it is more infectious. It is considered 4 to 5 times more infectious than the original COVID virus. It has proven to spread a lot faster and rapidly through communities, particularly those that are unvaccinated. The people that carries the Delta variant or are infected with the Delta variant have approximately 1,000 times more viral material, and that can be expelled through the secretions of the nasopharynx of those that are infected. And if expose others that are susceptible, it is more likely that it is infect a lot more people and a lot faster.
Okay. So then how does that relate to the 150 some odd thousand people that are unvaccinated in our community?
Well, if we have
again, before Dr. Ocarranza answers, I would renew my objection and also add that the exhibits presented here, the city's exhibits B and C, there do not even draw a distinction in terms of the mask requirements between the vaccinated and the unvaccinated. In other words, all individuals are required under that edict to wear masks. So again, I object to relevance, given that I don't think that this is salient to the legal issues, the controlling legal issues here. But again, there's no distinction even drawn within Dr. Ocarranza's order. So again, I object to relevance.
Overruled. And Mr. Lasley, before you continue with your questions, well, go ahead and answer that question, Dr. Ocarranza, if you.
Yes, can you repeat the question, Mr. Langley? please?
Okay, let me
Yes,
stop you there.
I was asking,
Eh,
so
Mr. Lasley, Mr. Lasley, I'm sorry. And this is a good time for me to take a quick break. I'm going to take a quick break
Okay.
so that Ms. Chavez can have some time to rest her fingers.
I'm all for that.
And so we will take a quick or a short 10-minute break. It is 9:59. We will take a break and reconvene at 10:10.
Thank you, Your Honor.
Thank you, sir.
Thank you, Judge.
Okay. Is everyone ready to start up again?
Yes, sir.
Okay. With that, Mr. Lasley, you may continue.
Thank you, Your Honor. Okay, so Dr. Operanza, before we broke, you told us about the Delta variant, how infectious it is, and that it's in our community, correct?
That is correct, sir.
So I think my last question to you was, so what does that mean to the 150 some odd thousand people who are unvaccinated in our community?
Yes, what that means for the unvaccinated particularly is that 160,000 people are potentially able to get infected with the Delta variant. Given the statistics that we have on hospitalization and death, it is expected that if those people that are particularly unvaccinated get infected, we're going to be having approximately 1,600 to 3,200 people hospitalized. And also, if 2% of those 160,000 people develop complications and die, so that's going to be 3,200 people that are going to be dying in our community.
So you said 1,600 to 3,200. Do you mean 1,000?
16,000. I'm sorry. Yeah, 16,000 to 32,000 people.
And because of the increased infectious nature of the Delta variant, this I'll say surge that you're describing, over what time period would you expect that to occur compared to previous surges?
It will happen very fast because as we know that the Delta variant is more infectious than the previous virus, we will expect that it can happen very fast.
So do we have enough hospital beds in our community to care for that many people infected with COVID-19?
No, sir, we do not have enough beds in our hospitals. And we do not have enough capacity to even care for our decedents in case that happens either.
So would you describe for the court how face coverings can reduce the transmission of COVID-19?
Yes, sir. The face covering works in two ways. One as a source control for those individuals that are infected with the COVID-19. As we mentioned, it produces 1,000 times more virus and it travels through droplets to infect other people. By having source control, meaning the face mask on those individuals that are infected, whether it is vaccinated or unvaccinated, we know that they can transmit the virus. It will help stop those droplets from reaching other people which are considered to be susceptible in avoiding the spread of the virus. Also, the face mask acts as a personal protection in which the mask is going to protect some of those droplets to land in the nose or the mouth of those individuals that are susceptible as well. So it protects both in both ways, the wearing of the mask. It is one of the tools that we have in public health to slow down and prevent the spread of the virus.
Okay, and so I think this next question maybe goes to something that Mr. Abramson was asking about. Your order is for everybody indoors across the county. Is that correct?
That is correct, sir.
Well, why that broad? Why not just one segment of our population?
Well, we cannot separate sections of our population. We're not built in silos. We cannot separate the 0 to 17 years of age without having their parents, which are between 18 to 45 or 45 to 65. Our community also has multi-generational homes in which we have the senior citizens. Our culture cares for our senior citizens. We as family units care for the most vulnerable, which are the senior citizens. We don't believe in sending those older relatives to nursing homes. So we cannot separate it and only put the mask in only one section of the population. Our community is one and it's a whole, and we cannot just partition that and only order the mask on a certain percentage of the population.
Okay, Ms. Anchondo, would you please bring up D1? Excuse me, D2. Thank you. So how is your mask mandate working, doctor? Is there, can you use D2 to help explain that to the court?
Yes, sir. What we try to depict here in the dotted line is the mask mandate. It was instituted after CDC week 32. And after we instituted, we saw about approximately 10 days of an upward trend, and now it's stabilizing and going down. I believe in its mask mandate is working, it's doing its intent, and it's slowing the spread of the virus, and we're seeing a less number of positive cases in our community.
And Ms. Anchondo, could you pull up D2? And on that particular issue, what's depicted here in Exhibit D2?
Well, in D2, as mentioned, the dotted green line to the right, we can see that the number of positive cases has stabilized now by CDC week number 34, and we see a slight decrease on the number of positive cases.
How long is it typically that does it take once you have instituted a measure like the mask or face coverings that you start to see the results of that effort?
Between 10 to 14 days, we have seen that it starts every time that we have an intervention. Between 10 to 14 days, we see the effects of that intervention that we established.
And so is that what we're seeing here in our data that described in D2 in D3?
Yes, sir.
I'm sorry, D2.
Yes, sir.
Okay, let's see. And then let's go to D3, please, Ms. Anchondo. And so could you explain to the court how this data reflects the effects of your mask mandate?
Yes, sir. The dotted green line also reflects the mask mandate. We can see that it continued to go up, but now we're seeing a sharp decrease in the number of cases, particularly in the 0 to 17 age group and the 18 to 30 age groups, as well as the 31 to 45 age group. We can see also on the 65 and older that it has plateaued and stabilized, and it hasn't continued going up.
Okay, and so then in the yellow line there, that's our older adults, correct?
That is correct.
All right, so what would you explain for the court what you see there?
Yes, it's going up, and it has an upward trend on the number of positive cases on these older adults. These older adults also are productive members of our community. They have the necessity to go to work. They cannot stop working, and they cannot afford to be working because they're the ones that are supporting the whole family and the household, including our senior citizens that we're caring for and that we're trying to protect as well. It is a benefit to have them healthy, and it is a benefit to have them being productive. People at this age group cannot afford to be hospitalized because they're not going to be productive if they're hospitalized or they pass away.
And do you expect, if your mask mandate stays in place, that the data with regard to that age group will level off and ultimately decrease?
Yes, sir. I will expect that.
Your Honor, just very briefly, I would object to a lack of foundation for that question, as well as to some degree calling for speculation. I would ask that more foundation be laid before saying whether or not we'll see a diminution in cases due to masks, or the mandate, that is.
Mr. Lasley, will you provide more of a foundation, please?
Sure. Okay. So as the local health authority, have you had the opportunity to review previous data during the course of the pandemic that related to the effects of mask mandates?
Yes, sir. We had the opportunity to review the data, and in July 2020, we were experiencing a second wave of the virus. We saw an upward trend that it was sharp, and the governor of the state of Texas instituted a mask mandate. Soon after, 10 to 14 days after the instituting the mask mandate by the Texas governor, we saw a plateau and a decrease in the number of cases, and our second wave was over.
And that result or that effect, did you see that across all of the different age groups in our community?
Yes, sir.
All right. And based on that experience and your other training and your job as the local health authority, then do you think it's reasonable for you to expect that you'll see the same result with regard to these age groups, including our older adults, in response to your mask mandate?
Yes, sir. Based on that previous experience and based on my expertise, I expect that it will happen.
So does the virus care if the governor issued a mask mandate or if you issued the mask mandate?
In July 2020, it was the Texas governor who issued the mask mandate.
So the virus didn't care.
No, sir.
Would you go to D4, Ms. Anchondo? And what's demonstrated here in D4 with respect to the effect of your mandate?
What is demonstrated here on D4 is that by the dotted gray line, which was the mask mandate was instituted, we can see that the number of hospitalizations has plateaued and started to decline.
Okay. And is that as you expected?
Yes, sir. That's what I expected after having an intervention, that we would see a positive effect by giving the mask mandate.
And then, Ms. Anchondo, can we go to D7, please? All right, would you explain for the court what is what you're demonstrating with the data here in D7?
Yes, this chart demonstrates the school-age children and the number of positive cases that we had. To the right of the red line, it means this academic year, and the dotted green line, it is the mask mandate. We saw that after the school started for in-person instruction, we saw a sharp increase in the number of cases in the school-age children, which after the mask mandate, we saw that it peaked and now it's starting to go down.
And then would you bring up D8, Ms. Anchondo? Is this a further breakdown of these school-age children?
Yes, sir. This is a further breakdown of the school-age children in which we have the age groups of these school-age children. We see that after the mask mandate, we continue to see that upward trend, that it was very sharp and steep. But after CDC week number 33, now we see a decrease in the number of positive cases.
Now, so these are very good results, correct?
That is correct. Because
all right. And would you explain for the court why the mandate wouldn't be as effective if it was just for kids in school?
Well, we wouldn't see the positive effects across the whole community. We know that the children belong to a household. We cannot separate the children from the household. And our households are having adults that are considered very vulnerable, that have diabetes, have high blood pressure, have some of the other comorbidities that we have seen. That will prompt them to require hospitalization and even pass away from complications of COVID-19. We cannot separate different sections of our community and protect some, but not the other. They're going to be promoting the transmission of the virus within the household and within the community as well.
Okay. Has Governor Abbott's Executive Order 38, or referred to, I think, as GA 38 by a lot of folks, has that been an impediment to your mask mandate?
Yes, sir.
And in fact, that's why we had to sue the governor, right? Is because of that impediment. Is that correct?
That is correct, sir.
So rather than just issue the mandate, we've had to sue the governor so that we can ask the court to declare that you've got the authority to issue the mandate. Is that right?
That is correct, sir.
So what's going to be the effect in our community with regard to this virus if your mask mandate does not continue?
What I expect to see is that we're going to continue to see a sharp rise in positive cases, hospitalizations, and ultimately, we're going to see many people dying from complications of COVID-19 in our community.
So essentially, more people are going to get sick and die than would otherwise.
Yes, sir.
So are you able to fulfill your duties as the local health authority without the full authority that's granted to you by statute to carry out that job?
No, sir.
Your Honor, I pass the witness.
Thank you, Mr. Leslie. Mr. Abramson?
Thank you, Your Honor. May it please the court. Dr. Ocaranza, my name is Daniel Abramson. I'm with the AG's office. Dr. Ocaranza, you're not the governor, correct?
That is correct.
In fact, you're not even an elected official, are you?
No, sir.
In order to obtain your position, you didn't run for office, you were appointed, correct?
That is correct.
In your duties as a citizen of the United States and the state of Texas, you have to follow the law, correct?
That is correct.
And more importantly, in your official duties as a local health authority, you have to follow state law.
That is correct.
GA 38 is state law.
Objection, Your Honor. It calls for a legal conclusion from the witness.
Sustained.
Were you aware of GA 38 at the
Yes,
time?
sir.
Pardon? Was there an objection? Dr.
No, I
Ocaranza?
didn't make an objection.
Okay. Dr. Ocaranza, were you aware of GA 38 at the time of the mask mandates release on August 17th, 2021?
Yes, sir.
You were aware of the contents of GA 38?
Yes, sir.
You were aware in your capacity, you had read it. You were familiar with the text of it.
Yes, sir.
Nevertheless, you publish a mask mandate for El Paso, correct?
That is correct.
I noticed when you were on direct, you were asked, was GA 38 an impediment? You felt that GA 38, the governor's authority, state law, was an impediment.
Your Honor, I make the same objection about the legal conclusion. He's put it into the premise of his question.
Sustained.
Dr. Ocaranza, you felt GA 38 was an impediment.
I felt and I testified that it is an impediment to fulfill my duties as a local health authority.
And because you felt it was an impediment, you felt that you could ignore it.
Objection, Your Honor, that mischaracterizes his previous testimony. He's already testified that we had to sue the governor for a declaration that he has the authority to enter the order.
Sustained.
Dr. Ocaranza, you understand that when it comes to any type of mandate, there is a balance of interests, correct?
I don't understand what's the balance of interest.
Well, allow me to clarify. I'm going to point here and I'll screen share if you'll allow me. Dr. Ocaranza, I'm looking at State's Exhibit B here. This was your first mask mandate order, and then we're going to go to State's Exhibit C. But what I'm noticing here is this list of exceptions 1 through 10. And let's get to the more recent one on August 27th. So allow me to clarify my question. You have an exception, for example, any person while the person is consuming food or drink, correct?
Yes, sir.
And is the reason for that exception because you're trying to balance economic interests with health interests? In other words, if people could never remove their masks, that would do some pretty severe damage to local businesses, particularly restaurants and bars, correct?
No, that's correct. And also there's some medical facts in that because you cannot eat when you're wearing a mask.
Well, obviously, right? But most restaurants are indoors.
Yes, sir.
And there's nothing magical that happens during the consumption of food or the drinking of a beverage that prevents the transmission of a virus.
That is correct.
Right. So what you're doing is you're making a policy call.
No, sir. It is a medical decision and a medical order to protect the health and well-being as being in the statute and as being my duty as local health authority.
Dr. Ocaranza, I'm not trying to trap you. What I'm saying is you're balancing certain interests, right? Because you don't say that people have to wear them when they go swimming, for example, or even in the gym. If we scroll down here, any person, while they're in a swimming pool, I would imagine that's because it would lead to absurd results, correct?
That is correct.
Look at number 4 here. While that person is exercising or engaging in activity in a gym, again, that's an indoor facility. Somebody is exhaling, but you've carved out an exception there. That's a policy call, right? Isn't it?
Objection, Your Honor, asked and answered.
With regard to number 4, Your Honor, it has not been.
Overruled.
It is an exception based on the evidence on the transmission and also on the risks for those that are doing that activity indoors.
Dr. Ocaranza, you understand how your mask mandate, both of August 17th and of August 27th, and I'm not asking for a legal conclusion, I'm saying they are materially different than GA 38. Correct?
Your Honor, I think that's vague. What does he mean they're materially different? In what respect?
What I'm saying is GA 38, you admit you're aware of it, correct?
Yes, sir.
You admit that you have you've not reached a conclusion that it is not state law, but I won't go into that. Is it your professional opinion that the mask mandates you have ordered are in compliance with GA 38?
I'm not a legal professional. I'm a medical professional.
I understand. I'm asking you as a medical professional.
As a medical professional.
Objection, Your Honor. Objection, Your Honor. It asks him to make a legal conclusion.
Sustained.
Dr. Ocaranza, regarding childhood masks, you understand that there are parents who believe that decision should be theirs and not that of a local health authority, correct?
Yes, correct.
And there are some parents who are concerned about the effect on, let's say, childhood development, where children who don't see the faces of others could have impediments in their childhood development. Are you aware of that?
I was aware of those concerns on those parents.
But you feel that you can substitute your judgment for that of parents.
Well,
Objection, Your Honor. That mischaracterizes the basis of the order that Dr. Ocaranza entered.
Sustained.
Dr. Ocaranza, I'm going to pull up what has been marked as City's Exhibit D. This is what you had been asked about. Is my screen sharing? Can you see what I'm looking at here?
yes, sir.
So I'm going to go one by one. Just to be very clear here, when I'm looking here at 2021-5 total cases, that would be the 5th week of calendar year 2021, correct?
That is correct.
And when we're looking at, let's say, 2021-20, that would be more or less the 20th week. So we'd be, I suppose, about May, correct?
More or less, yes, sir.
Okay. Do you know when Governor Abbott ended the mask mandate? March. Go ahead.
I cannot recall exactly the date.
Does it sound like maybe March was the date? Early March?
I cannot recall exactly what the date is.
do you notice what the rate of total cases, let's say, and if we can say with about 4 weeks per year, March would be around 12 or so, correct?
Yes.
Okay. And if we look here, and I'm going to use my pointer, we see about 1,000 here when we're looking at that number of total cases. But then let's move forward to the 24th week. We're far below 500 there, correct?
Yes, sir.
And this was after the mask mandate had ended, correct?
Yes, sir.
Looking at the total cases by age group, we're now at Cities Exhibit D3. Obviously, you were pointing to the rise in the curve, but Dr. Ocaranza, if we look here, it seems like there's a break point there in week number 32. In other words, the line is going up for people who are ages 0 to 17, fair?
Yes, sir.
And then it begins to drop around week 33, and in week 34, we're seeing it's dropping down, correct?
That is correct, sir.
Now, you attributed that in your testimony to masks, right? You said that it was because of masks that we're seeing that drop.
Yes, sir.
And you didn't attribute it to anything else, did you?
No, sir.
But the fact is that school had started, right? So there could be a rise in cases when school starts and people are getting back together, and then a drop.
Yes.
In fact, there could be any number of factors that could have led to that drop.
It could be, I guess.
Yeah. I mean, moreover, Dr. Ocaranza, I want to ask you about D4, but that brings up another topic. You again attributed that to masks, but your order does not specify the types of masks that one must wear. In other words, any fig leaf of protection will do, correct? In other words, you say a handkerchief would work, correct?
Yes, sir.
Or somebody could wear a cloth mask.
That is correct.
Or a paper mask.
That is correct.
Or an N95.
N95, and my order says that it's highly recommended the medical grade mask.
Fair enough. But your testimony is that even though you don't draw a distinction between the efficacy of those types, you're saying that you would attribute that drop entirely to mask, or have you changed that now? Now it could be a number of things.
Objection, Your Honor, that's argumentative.
Sustained.
Dr. Ocaranza, I want to point you to Cities Exhibit D4. Again, we're looking here at hospitalizations for record purposes. Dr. Ocaranza, kind of the same question, just again here for the record. I'm looking at 2021-5. That would be the 5th week of calendar year 2021, correct?
That is correct, sir.
And we see 250 hospitalizations, correct?
Yes, sir.
And in previous testimony, I said, you know, I think we agreed, and we don't have any objection that the mask mandate ended in March. So if we look around March, right, let's say around 12, we're looking at about 100 or so, thereabouts, correct?
Yes, sir.
And then we kind of go out to 2021-23, 24, and we're quite a ways below 50, correct?
Yes, sir.
And this is after the mask mandate has ended.
Yes, sir.
And overall, hospitalizations today, or at least they're on week 34, are lower than they were in week 5, correct?
Yes, sir.
And in fact, if we look at that number there, much like the previous part, which is states, or rather cities D3, where we see a drop, let's look at Cities Exhibit D4. It looks like there is a drop that seems to plateau around week 33 and drop in week 34, correct?
Yes, sir.
Dr. Ocaranza, you made an issue of the rates of the hospitalization by age and the rates. I'm pointing here to Cities Exhibit D5. Can you see what I'm looking at here?
Yes, sir.
Okay. looking, let's say, at week 34 here, there's a breakdown of 0 to 17, 18 to 30, 31 to 45, 46 to 65, and 66 plus, correct?
Yes, sir.
If we add up the percentage of those over 65 and over 46, that's the majority of the hospitalizations, correct?
That is correct.
And it leads me to this, which is City's Exhibit D7. What we're looking at here is cases per 1,000. And this is starting at week 9, approximately a little less than 2 per 1,000. Is that correct, sir?
Yes, sir.
Okay, and then after, and during the summer, this goes down to less than 0.5 per 1,000. And much as, I'll let you answer.
Yes, sir.
And much as in, we saw in the previous exhibits in week 33 and week 34, we are seeing a drop in numbers, correct?
Yes, sir.
Dr. Ogaranza, obviously I want to preface this by saying that any death is a tragedy, particularly those of the young, but is it your professional opinion that in terms of the lethality of COVID-19 for children, particularly young children, the seasonal influenza in terms of sheer numbers is equally or even potentially more deadly for children? Is that correct?
Object to relevance.
Judge, if you'll allow me, I will ask a follow-up that will make it relevant.
Go ahead, Mr. Abramson.
Thank you, Your Honor. Would you agree, Dr. Ogaranza? In fact, I've seen numbers that say less than 0.25% of the deaths from COVID-19 are children. Does that sound about right?
I object to Mr. Abrams testifying, Your Honor.
Sustained.
Would you agree that COVID-19 presents less of a lethal threat to children than to adults, particularly older individuals with comorbidities?
Yes, sir.
Okay. Dr. Ogaranza, what I'm going to ask you is, and Judge, this was my follow-up question, given that the seasonal influenza was quite bad in the 2019-2020 calendar year, you didn't order a mask mandate then, did you?
I object, Your Honor. That question has facts that are not in evidence.
Sustained.
Dr. Ogaranza, how is GA 38 an impediment?
It eliminates a public health tool from the ability to implement control measures.
Do you believe that you have superior authority to the government or to the governor to set standards for El Paso?
I object to the term superior.
Sustained.
We'll pass the witness, Your Honor.
Thank you, Mr. Abramson. Mr. Lasley?
Yes, Your Honor, thank you. Would you unshare your screen, please, Mr. Abramson?
Yes.
Thank you. Ms. Anchondo, would you please share your screen with exhibit, start with exhibit D2, please? D2, there you go. Thank you very much. So this with D2 shows our total cases, correct? Dr. Ogaranza?
That is correct, sir.
All right. So would you describe for the court when we started to see the Delta variant in our community?
Yes, sir. We started to see the Delta variant in our community around CDC week number 24.
All right, and does that explain the increase in cases that we see following that week?
Yes, sir. That explains the sharp increase in positive cases that we saw in our community.
Okay, and then with respect to the decrease in cases that we see at weeks either 33 or 34, what were we doing differently after week 32 that we weren't doing before week 32?
The thing that was different was the implementation of the mask mandate.
Was anything different other than that?
No.
Could we see D4, please? So this is our hospitalizations. Would you, with regard to this chart, would you explain to the court when we started to see the Delta variant in our community?
Delta variant we started seeing approximately around CDC week number 24.
And would that explain the increase in our hospitalization?
Yes, sir. That explains the increase in the hospitalization that we saw in our community.
All right. And then with respect to the leveling off or decline of cases in week 33 and 34, what were we doing differently at that time that we weren't doing before?
The mask mandate was the only thing that we saw that we did different.
So is that true with respect to all these different charts and graphs and all these different age groups?
Yes, sir.
So would we benefit from masking elderly people and not kids, or kids and not elderly people?
No, sir, we would not see the same benefit because the mask to be effective has to be a universal mask in individuals 2 years of age and older.
And that's what we saw with the previous mask mandate by the governor, isn't that correct?
That is correct.
Mr. Abramson asked you about economic interests. So what's better for our economy in our community? Would it be to have 15,000 hospitalized people and 3,200 dead El Pasoans? Or would it be better for our economy that we had a decrease in the number of infections and hospitalizations?
Judge, I'm going to object. Dr. Ocaranza has not been certified as an economist. If he's not qualified to even admit that GA 38 is valid governing state law, I don't think we should have testimony as to what he thinks the statewide economic outcomes will be from a mask mandate. There's been no foundation laid, and he's not an economist.
So his objection mixes apples and oranges there, Judge. So with respect to his opinion about whether or not the effect of GA 38 legally was a legal conclusion, but Mr. Abramson asked Dr. Ocaranza about balancing economic interests. In fact, Dr. Ocaranza answered a couple of questions with regard to that very issue for Mr. Abramson. So he's opened the door to it.
Not to speculation as to what will the long-term effects of this be. To note that his order of August 17th and August 27th, as opposed to, carves out exceptions, is different than asking this witness to speculate as to what the effects will be, which is what counselor is asking him to do. Moreover, he has not been certified as an economist. And if counselor wants to object to the notion that Dr. Ocaranza is aware that GA 38 is valid state law and nevertheless violated it, I don't think he should be opining on the best economic path for the state of Texas.
So, Mr. Abramson, I'm going to go ahead and sustain your objection, although I believe Dr. Ocaranza's order was implemented after the TRO was issued by this court. You may proceed. Mr.
Okay.
Led.
So you're a citizen of this community, correct, Dr. Ocaranza?
Yes, sir.
And you're a business owner, is that right?
Yes, sir.
And as the local health authority, have you been able to observe the various effects outside of just the hospitalizations and deaths in our community, but the various effects that the virus over the past year and a half has had in our community?
Yes, sir.
And have you been able to observe the effects of the various surges of the virus in our community?
Yes, sir.
And have you seen the effects on people's ability to go to work?
Yes, sir.
Have you seen the effects on the people's ability to go out and spend their money?
Yes, sir.
So with regard to those particular effects in our community, which is better, to have a whole bunch of people hospitalized and a bunch of people dead, or to have people wear a mask and tamp down the virus in our community?
Based on those observations, it's better to have the mask and carry out their activities.
Pass the witness, Your Honor.
Mr. Abramson?
Thank you, Your Honor. Is it because you think it's better, as you just stated, Dr. Ocaranza? Is that why you willfully ignored GA 38 in
Objection, Your Honor.
issuing your mask mandate of August 27th?
Your Honor, I object. That's argumentative, and the court just reminded Mr. Abramson that Dr. Ocaranza did not enter his order until the court entered the TRO.
What about your order? Go ahead. I'm sorry, Your Honor.
That's sustained, Mr. Lasley.
Pass the witness, Your Honor.
Thank you.
I've got nothing further, Your Honor.
Thank you, Dr. Ocaranza. You are excused.
Thank you, Your Honor.
Subject to recall, I'm assuming, correct, Mr. Arambula, Mr. Lasley?
Yes, Your Honor.
Okay, I'm assuming there won't be, but just in case.
Well, better safe than sorry, right?
Yes, sir. Mr. Arambula?
No further witnesses, Your Honor.
Okay, thank you, Mr. Arambula, Mr. Lasley. Mr. Abramson?
Your Honor, we will not be calling any witnesses.
Okay.
Your Honor,
So-
we would move, we just want to make sure that the text of GA 38 is itself in evidence. And so before we rest, we would move Defendant's Exhibit 1, which I don't think I've emailed to the court, but we happy to do. I mean, it's just GA 38 itself.
We don't have any objection to that, Your Honor.
Thank you, Mr. Dower, and I do have a copy of that. So
Okay.
Defense Exhibit 1 is admitted.
And I think with that, Your Honor, defense rests as well.
They rest as well, Your Honor. I note, Your Honor, that we're about at the 1 hour mark. I would suspect that our arguments are going to take, I don't know, maybe 15, 20 minutes. I'm just guessing. I don't know if the court, consistent with its last break, would like to take one before so that our arguments aren't really split up. But I'll defer to the court.
No, and that was my intent, just making sure that everybody's finished presenting their case, but I will give Ms. Chavez another break. Arguments are a little, take more work. Let's put it that way. As opposed to the examination of a witness. So we will take a break. Either party requesting any amount of time, or is 10 minutes fine?
I think 10 minutes is sufficient, Your Honor.
We agree, Your Honor.
So it is 10:54, and as we did the last time, you're going to end up with 11 minutes. So we'll start up at 11:05.
Thank you, Your Honor.
Thank you,
Thank
Judge.
you. Okay, we are now at 11:05. Thank you, everyone, for returning promptly. And we're ready to get started with your closing presentation, closing arguments. And with that, Mr. Arambula, if you are ready.
I'm ready, Your Honor. Thank you.
You may proceed. Thank you.
So, Your Honor, the evidence you just heard from Dr. O. Carranza, the city put on that evidence because it is necessary for the court to understand what the COVID pandemic, and more specifically, the Delta variant, has caused over the last few months, why a mask mandate was necessary. And despite the cross-examination you saw, one of the more interesting things, I think, and this is, by the way, a fairly obvious position. The office of the governor actually does believe in mask mandates. How do I know that? Defense Exhibit 1, that's GA 38 in subsection 4A, actually provides exceptions to the mask mandates. Those are for state-supported living centers, government-owned hospitals, government-operated hospitals, the Texas Department of Criminal Justice, the Texas Juvenile Justice Department, and county and municipal jails. So the governor has recognized mask mandates can work. The difference is that here, what he's done is he's provided an exception for certain entities to make or retract mask mandates. What he hasn't done is provided that same authority to local health authorities who know what's happening in their communities, who can make informed decisions, and who can decide based on the science that's applicable in their, the facts applicable in their jurisdiction, whether or not this should be done. And ultimately, I will agree with the Attorney General's office on this particular issue. This case really isn't mostly about the facts on the ground, because I think the facts are uncontroverted. Masks work. Mask mandates are an unfortunate aspect of life, and they've worked. They've worked from the flu pandemic at the beginning of the 18th century. They work today. You saw evidence today that, in fact, every single time, soon after a mask mandate was ordered, cases went down. I don't think that's contested in any meaningful fashion. And the AG asks, who has the authority? Well, fundamentally, that isn't the right question. And the motion that you have before you, both the motion in opposition to the preliminary injunction and also the plea to the jurisdiction, frame this as who has the authority. That isn't the question before the court, nor is that the question we're going to ask this court if it reaches the stage of a bench trial, which we will be requesting. The question is this: does the governor actually have the authority to do so, to engage in this particular action? And the uncontroverted case law on this very directly points to the answer, no. And why is that? I will go step by step and I will point to the court, Supreme Court precedent, and constitutional provisions from the Texas Constitution that say exactly that. So let's begin. I'll begin first, Your Honor, by going through the requirements for a temporary injunction: a cause of action, a probable right to relief, and imminent injury in the absence of a temporary injunction. So the first part of this is there a cause of action? So here, I think I can kind of narrow this down to a couple of issues. And if you'll note, Your Honor, our original petition framed the problem in the alternative, because it all boils down to one issue. The Texas Disaster Act has certain provisions that the governor has repeatedly misinterpreted, and he's made an astounding grab for power that was both unprecedented within the text of it and in the history of the Texas Disaster Act. And it boils down to one particular section, that is section 418.016A. In that particular section, what happens is that the governor repeatedly and in GA 38 cites that provision for the governor's authority to suspend regulatory statutes to mean essentially any statute. I mean, and this isn't even, this particular assertion doesn't even withstand a quick view of this particular the Texas Disaster Act. The section right before it, section 418.0155, is a check on that. Why? Because that section, it creates, or it imposes upon the governor the duty to have a suspension list. That list is supposed to inform state agencies of what laws he's going to suspend, so that I would assume that they would actually have some kind of notice as to what actions they may take in the event that their rights to engage in certain conduct get suspended. I haven't seen any such list, and moreover, GA 38, like every preceding and every following executive order, actually has a catch-all clause that states that the governor is suspending any laws that he deems, and they're all unnamed, by the way, but it's a catch-all provision that says that he suspends any laws that would contravene the spirit and or the letter of his order. That can't possibly be the way that the Texas Disaster Act is designed. And that's actually one of the things that we are arguing. And when it comes to the issue here, if the governor is misinterpreting that specific section, then any acts that he undertakes in pursuit of his authority as a governor are ultra vires. And there's absolutely nothing that bars this lawsuit. So for example, the Texas Supreme Court in Hall versus McRaven found that a government officer with some discretion to interpret and apply the law may nonetheless act without legal authority, and thus ultra vires, if he exceeds the bound of his granted authority, if his acts conflict with the law itself. When you actually read section 418.016A, it says regulatory statute. The way the governor reads it, it removes the word regulatory and just says laws. Well, that can't be it. Basic principles of statutory construction state that each phrase in a law is read not only within context of the rest of the law, and here we're talking about the rest of the Disaster Act, but it's also meant to be read as a modifier, in this case, regulatory statute. That's one of the questions we will be asking this court to determine. Now, if the acts are without governmental authority, those acts are then ultra vires, and sovereign immunity does not actually bar any lawsuit of any kind, because the city, just like every other entity and every other person in this state, has the right to challenge the governor's authority when he believes that that authority has either been interpreted more broadly or contrary to established law. That's all we're doing here. We're asking this court. The Attorney General's filings essentially say this: the governor's interpretation of these laws are beyond review. That is the ultimate thing that these petitions are saying, that apparently we can't come forward and challenge the governor's authority. So in this particular case, it's interesting because if the governor's authority as he sees it is actually on point, guess what? The evidence that we presented to you, that was pursuant to Dr. Ocarranza's duties when he collected the numbers of deaths, the numbers of infections and all that. He has to do that by as a result of his duties as an LHA. And if the governor's interpretation of the law is accepted, well, guess what? He can actually bar Dr. Ocarranza from actually obtaining or even looking for that information. We wouldn't have even had that evidence if the governor decided that under his I guess claim to authority that was the case. He could have barred him. But that's exactly why we're here. We're here because this interpretation is so broad as to be meaningless. And as a general rule, a public officer has no discretion or authority to misinterpret the law. And that's pretty straightforward. That's the Texas Supreme Court, once again, in Houston Belt and Terminal Railroad Company versus City of Houston. And I'll give the court the site, 487 Southwest 3rd, 154. And that's from 2016. So this is recent case law. Now, the governor is arguing that he can suspend regulations where strict compliance, and this is, by the way, from GA 38, with provisions, orders, or rules would in any way prevent, hinder, or delay necessary action in coping with a disaster. That's what's baked into every single executive order. So he's simply saying that anything that interferes with what he believes to be the proper, I guess, the proper rollout or the proper or his authority to actually handle this disaster, he can just summarily suspend it. That's essentially what he's saying. And a declaratory judgment is made for the specific purpose of deciding whether or not the governor actually has this authority. So that's why it's a two-pronged question. The first question is this: is he interpreting that statutory provision properly? And if he is it constitutional? Now, one of the arguments that the Attorney General's office fails to address in any of their pleadings is how the governor's authority to suspend statutes, because let's be clear, that's exactly what's happened repeatedly. They've purported to suspend statutes for the purposes of actually responding to the COVID pandemic, right? So that's the real question here. But suspending statutes is prohibited. First of all, the only arm of Texas government who can do so is the Texas legislature. Texas Constitution, Article 1, Section 28 explicitly says, no power of suspending laws in this state shall be exercised except by the legislature. It says what it says. That's black letter law right there. And then Texas Constitution, Article 2, Section 1, which is the non-delegation clause, states that no branch of government shall exercise any power properly attached to either of the others, nor the exercise of any power properly attached to either of the others, except in the instances herein expressly permitted. No such authority has either been granted or, as far as I can tell, either asked for. More importantly, the AG's office has repeatedly, well, I'm not gonna say repeatedly, but they haven't addressed the Supreme Court precedent, and I'm talking about Texas Supreme Court precedent, directly on point here. The Texas Supreme Court clearly stated in the Brown Cracker and Candy Company versus City of Dallas, that's 137 Southwest 3rd, 342, and that's a case from 1910, which tells you how old this precedent is, where they said that the suspension clause does not permit the legislature to delegate to anyone else the authority to suspend a statute law of the state. It means what it means. There's no delegation, period. But what you're not going to hear, I would guess, is actually any response to that direct legal principle. There can be no delegation of the suspension of powers. There just isn't. But the governor has repeatedly read it that way. As to a probable right for relief, well, the court has to look at all of the evidence presented to it, as well as a case law and all of the arguments that are presented in that in support of the probable right to relief. And here, the city has shown, and if you look at the pleadings and if you look at the arguments, Your Honor, you're going to find that we not only have a probable right to relief, I don't know that there is a fundamentally sound argument that the office of the governor actually has this authority, because that's why the office of the governor has been repeatedly sued, because this is an overreach of epic proportions when it comes to the simple claim that the governor, that under the Texas Disaster Act, that he can simply suspend laws at will. And that's what he's saying. As to the irreparable injury here, there is no more irreparable injury than death. Dr. O testified to this court what would happen in the absence of a mask mandate. What's going to happen is we can't pinpoint who, and we can't pinpoint when. But one of the certainties that will come from the lack of a mask mandate is that more people will die. It's a plain fact. More people get infected, more people are hospitalized, and more people die. It's an unfortunate truth right now that mask mandates are, at least at this particular point, one of the few things that our local health authority can exercise in order to actually fight the pandemic. And the Delta variant, more specifically, because I think, as the court already knows, and as the court heard in testimony today, It is more virulent by a lot than the Alpha variant or any other variant, and it's prevalent. And in order to demonstrate a probable injury or harm, the applicant, here obviously the city, must show an injury for which there can be no real legal measure or damages, or none that can be determined with a sufficient degree of certainty. Here, it's going to happen. There will be death. I think that's a foregone conclusion. That, by the way, is a quote from Universal Health Services, Inc., v. Thompson. That's an appeals court case from Austin, 24 Southwest 3rd, 570. That's from 2008. The issue here, Your Honor, at the end of the day is this. Do we have a cause of action going forward? The answer is unequivocally, we do. The governor's authority in this particular case, and it's premised almost entirely on his reading of the Texas Disaster Act. And by the way, and if the court is inclined to actually hear the issue of the plea to the jurisdiction, if it's actually inclined to make a decision on that, I will address that briefly. The Attorney General's office, in their response, both to the responsive brief and in their plea to the jurisdiction, essentially cite to a couple of cases for the proposition that the city actually does not have standing to contest this issue or that it should go forward to trial. Their binding authority is in re Abbott. In re Abbott is not applicable. There's essentially a three-part test, and that's on page 7 of their application. In that test, the 3 questions asked are what are level, well, let me frame this. The argument there was state judges felt that their authority to carry out their duties were being infringed as a result of an earlier executive order. And the 3-part test that the Attorney General's office placed in their petition here addressed 3 matters. Number 1, what level of standing inquiry should apply to the judge's claims? What was the judge's loss of power a legally cognizable injury? And 3, did the judges establish a credible threat of prosecution? Well, let's begin with the last one. GA 38 has no prosecution authority in it, and that's based on its text. There's a fine of $1,000, but there's no credible threat of prosecution. So that can't be applicable here. Loss of power, we're not arguing that there's a loss of power. What we're arguing is that the governor still has no authority to engage in this based on the text of the Texas Disaster Act. And then the first one, what level of standing inquiry? As I stated before, Your Honor, when a government actor acts without authority, that can be challenged. So that isn't applicable here. And then as to sovereign immunity, the acts of the government without authority are ultra vires, and sovereign immunity does not bar a lawsuit. That comes from the City of El Paso versus Heinrich, 284 Southwest 3rd, 366. This case, Your Honor, in many ways is very straightforward. We're here just on the preliminary injunction. The preliminary injunction asks the court to decide 3 questions. We've laid out the evidence in support of those. And I think it's unequivocal that in this particular case, we've met that burden. As to whether or not there's enough here such that the court can deny the Attorney General's plea to the jurisdiction, we have also proven that. There is literally no reason why this court cannot hear this. Because in order for the court to find so, it has to either directly or impliedly find that the governor's findings in this particular case are essentially without review. When the governor says that he interprets the law to mean what it means, what he thinks it means, it's an unlimited grab, or I'm sorry, it is just an unlimited authority, essentially to suspend any law he wants during a Texas disaster. That's essentially it. There's not much more to that. And I'll point out just one last thing here, Your Honor, before I surrender, or I finish my opening closing.
You got my hopes up there.
I'm sorry, what?
I'm sorry. I didn't mean to interrupt. I was just saying that you got my hopes up there with the surrender comment, but I apologize. I didn't mean to interrupt your presentation, sir. I was.
That's okay.
Go ahead.
I meant surrender the floor. Maybe it was a poor way to phrase that. One of the issues here that the court's going to have to decide is the issue of whether or not, or what the status quo is. And I think with respect to the status quo in this particular case, the Office of the Attorney General has submitted a number of exhibits along with their plea to the jurisdiction. The most relevant of which is an order by the Texas Supreme Court where they argue that the status quo in this particular case is that the status quo for many months has been gubernatorial oversight of such decisions at both the state and local levels. Well, what that means directly is this, Your Honor. It means that according to their theory, that the status quo in this particular case would be a period in time whenever the governor has not has been able to engage in whatever he deems appropriate, whatever actions he deems appropriate while dealing with the Texas disaster, with the COVID pandemic. Problem is this: the governor has been repeatedly sued. He's been sued by cities, counties, school districts, nonprofits, and even by the federal government for his enactment of certain executive orders. That can't possibly be it. And the Attorney General's own precedent that they cite for this particular proposition says that the last non-contested act is the status quo. Well, of course it is. But the last non-contested act here was the time period before there was a mask mandate. I think it's safe to say, I don't know, but this case is about mask mandates and the governor's authority to order those. If there wasn't a mask mandate and Dr. O could order a mask mandate, I don't think we would be here. So the status quo is any period of time prior to that. It just simply doesn't make sense to argue that it's when the governor essentially ran the state without being sued, because that's been I don't think we need to look at the news all that often to know that he's repeatedly sued. And even the Office of the Attorney General admitted that at this particular time, there's like 9 lawsuits. So he's getting sued, and he's getting sued repeatedly for that. So the status quo can't be that. It is, I would argue to the court, the period of time directly preceding the mask mandate, because that's what this is about, even though more broadly, it is about the governor's authority to simply order the suspension of any statute. At this time, that's the closing of my first argument, Your Honor. Thank you.
Thank you, Mr. Rodriguez. Bauer?
Yes, Your Honor. Let me make sure I'm not getting any reverb. Okay. Your Honor, I have, I know everyone loves PowerPoint presentations, but I do think showing some of the text will be helpful. So I have a PowerPoint presentation if the court will indulge me. Okay. Can Your Honor see the slides?
Yes, I can. Thank you.
Okay. Thank you, Your Honor. Okay, so I want to start with the Texas Disaster Act, which is the statute that we're talking about. It's quite a large statute with a number of provisions, but it provides an emergency management system embodying all aspects of both pre-disaster preparedness and post-disaster response, as well as obviously everything in between. And it's important to note that the purpose is not just to mitigate the damage, injury, and loss of life and property resulting from the disaster, but also to provide a setting conducive to the rapid and orderly restoration and rehabilitation of persons and property affected by disasters. And under the Disaster Act, the governor is responsible for meeting the dangers to the state and people presented by disasters. And he's imbued with a number of different legal powers and authorities under state law. One of which is that the governor may issue executive orders that have the force and effect of law. And this next one is particularly relevant to this case, that the governor may control ingress and egress to and from a disaster area and the movement of persons and occupancy of premises in the area of the disaster. The governor can also use all available resources of state government and of political subdivisions, which of course includes both cities and counties. And then we heard a little bit about the regulatory suspension, that he can suspend any regulatory statute prescribing the procedures for conduct of state business or the orders or rules of a state agency if these provisions, orders, or rules would in any way prevent, hinder, or delay necessary action in coping with the disaster. The Disaster Act does contemplate a role for subdivisions. It makes, among other things, the presiding officer of the governing body of an incorporated city an emergency management director for that, political subdivision. And the emergency management director serves as the governor's designated agent in the administration and supervision of duties under the Disaster Act. And so the emergency management director can exercise powers granted to the governor, but does so as the agent of the governor. Now, switching over to GA 38, it's important to note that GA 38, of course, does not prohibit people from choosing to wear masks or having their children wear masks. Individuals are encouraged to follow safe practices, such as wearing face mask coverings. So what we're talking about here is the difference between individuals choosing to wear masks or the government forcing them to wear masks. And as we heard earlier, the GA 38 prohibits local governmental entities and officials from requiring another person to wear a mask with some exceptions, but it's only to the extent necessary to ensure that local government entities or officials do not impose any such face covering requirements. So the important, why that matters is that if no statutes have to be suspended in order to supersede local authorities, then no statutes are suspended. And as I'll explain in a minute, no statutes have to be suspended in order for GA 38's prohibition on a mask mandate to take effect, to be effective. And the reason for that stems from the statute that I mentioned earlier that gives the governor power to control ingress and egress to and from a disaster area, and the movement of persons and occupancy of premises in the area. And I know that that may be initially counterintuitive, so let me sort of explain, how do you get from a prohibition on mask mandates to occupancy of premises and movement of persons? And so I'll just sort of demonstrate it through two scenarios. In scenario one, someone comes into, for example, a city or county building, and they're not wearing a mask. And under the order of the local health official, that person would not be permitted entry into the government building. Well, GA 38 overrides that and says, no, as the governor, I'm exercising my authority and I'm permitting the movement of persons into that premises. In the second scenario, someone is in the premises and they take off their mask. And then, of course, enforcing the local health authority, they would be asked to either put on a mask or forced to leave. And if they refuse to put on a mask, then they're escorted from the building. And again, GA 38 overrides that and says, no, I'm not going to let you make occupancy of premises be conditioned on wearing a mask. And this is the same authority that the governor previously exercised to impose the mask mandate we heard about earlier. So when the governor was himself doing a mask mandate, it was exactly this statute that authorized him to do so. And several of the other local health officials, or rather counties, are invoking this same type of power in order to authorize their mask mandates. And so that's how the language of the statute authorizes the GA 38's prohibition on local government officials doing mask mandates. And because that fully authorizes the mask mandate prohibition, no local governmental entities or official statutes are suspended. And there is reference to this in the language of GA 38 itself. It's included in the whereas clauses that there's this specific reference to 418.018C about this control of ingress and egress. And the reason for that is because this is part of the governor's authority for GA 38. So how is GA 38 enforced? Well, it is enforced through a criminal fine. There's this language in the whereas clauses that reference section 418.176, which is part of the Disaster Act, that authorizes an offense punishable by a fine of up to $1,000 for a failure to comply with the state emergency disaster plan or with a rule, order, or ordinance adopted under the plan. And the state emergency disaster plan actually says that violations of the governor's executive order are punishable by a fine of up to $1,000. And so the GA 38 basically takes that and says the imposition of any face covering requirement by a local governmental entity or official constitutes a failure to comply with this executive order and is subject to a fine of up to $1,000. And if you looked at 418.173, it also talks about punishable by jail time. Now, GA 38 doesn't do that. It explicitly disclaims that it's enforceable by jail time, but that's revealing because it reveals the criminal nature of the $1,000 fine, that it's not merely a civil fine, it's a criminal offense. So then going now to the substance of the argument, we asked the court to deny the plaintiff's application for a temporary injunction for 3 reasons. First, the city seeks to change, not preserve the status quo. Second, the city cannot and has not shown substantial likelihood of success on the merits. And third, the city has not met its burden to demonstrate an irreparable harm. So going to the first element, changing the status quo. So the purposes of a temporary injunction is to preserve the status quo of the litigation subject matter. And the Texas Supreme Court has already decided this very question. And I heard this argument, or this what I'm about to say next, as being the argument of the Attorney General's office. And I would just submit to the court, it's not an argument by the Attorney General's office. This is the words of the Texas Supreme Court just a short while ago. I think it was last Thursday, so 1 week from today. And so what the court held in this Texas Supreme Court said that this case and others like it are not about whether people should wear masks or whether the government should make them do it. Rather, these cases ask the court to determine which government officials have the legal authority to decide what the government's position on such questions will be. The status quo for many months has been gubernatorial oversight of such decisions at both the state and local levels. And then it goes on to say that the status quo should remain in place while the Court of Appeals and potentially this court, meaning the Texas Supreme Court, examine the parties' merits arguments. And so the Texas Supreme Court has already said that the status quo ante is gubernatorial oversight. And so the temporary injunction should be denied on the basis that it is attempting to flip that and allow the local government authority to ignore the governor's superior position on such questions. And so the Texas Supreme Court has already squarely addressed this exact issue. Moving to the substantial likelihood of success on the merits, the court lacks subject matter jurisdiction, and therefore the city has not shown that it's likely to prevail. And this is why, Your Honor, I said at the beginning of our conversation today that the plea to the jurisdiction is really intermeshed with the legal issue about substantial likelihood of success, because our whole argument on why the plaintiff has not shown substantial likelihood of success is that the plaintiff has not demonstrated this court's subject matter jurisdiction. And so the two are basically one and the same. And there's 2 reasons that the court lacks subject matter jurisdiction. The first is that the city lacks standing to sue the governor. And then the second is that the governor has sovereign immunity. So starting with standing, standing requires 3 things: an actual or imminent injury in fact, that is 2, likely or fairly traceable to the defendant's conduct. In other words, that the injury has to be caused by the person or entity that the plaintiff is suing, and that is likely to be redressed by the requested remedy. And this is the key point, that when you're challenging whether it's a criminal statute or an executive order, you have to sue the party responsible for enforcing the statute or executive order. And the reason for that is that the injury stems not from the enactment of the order or statute, but rather from its enforcement. And so just as someone doesn't sue the Texas legislature when challenging a state law, even though the legislature, passed and enacted the law, you can't sue the governor for issuing an executive order. What matters is whether its enforcement would be legal or illegal, and that's where the injury flows from the enforcement. And there are several cases that say this, but I want to focus specifically on the City of El Paso versus Tom Brown Ministries and the Abbott opinion. Starting with the City of El Paso, which is obviously an 8th Court of Appeals case from the El Paso Court of Appeals, in order to establish standing and a justiciable controversy between the parties, there must be an actual enforcement connection, some enforcement power or act that can be enjoined between the defendant official and the challenge statute. And I would add that that applies equally here to an executive order. So you have to sue someone who's going to enforce the law that you're challenging. And the court goes on to say that there must be a credible threat that the named defendant could bring the enforcement action against the plaintiff. And that's the same logic that the Texas Supreme Court used in this Abbott opinion, where it was a previous executive order. It contained an enforcement provision similar to GA 38, an offense of up to $1,000. And the governor was one of the defendants, and the governor said, look, I'm not going to be the one who enforces this. I can't bring a criminal action or charge someone or call someone into criminal court with an indictment. I'm not going to enforce this $1,000 fine. And the Texas Supreme Court said, well, that means that you don't have standing to sue the governor, since it's not going to be the governor who brings a criminal prosecution under GA 13. And that exact same logic applies equally here. And it's almost the same exact enforcement mechanism for GA 38 as in GA 13. And so based on this pretty well-established precedent, in order to sue, to challenge either whether it's a penal code provision or an executive order that creates a criminal offense, you would sue someone who could actually enforce it against you, such as a district attorney. So then switching over to sovereign immunity. So whenever you sue the state, which includes official capacity defendants, such as Governor Abbott, the plaintiff has that initial burden to establish a waiver of sovereign immunity. And my friend on the other side is right that the ultra vires exception is one way that you can get around sovereign immunity, but it only applies when the official has actually acted unlawfully. And so if the official has not actually acted unlawfully, the defendant that's being sued, the official, retains sovereign immunity. And admittedly, that means that the merits of the case, for example, the substantial likelihood of success on the merits, may become entwined with the jurisdictional question. And the Texas Supreme Court here recognizes that the jurisdictional inquiry, may unavoidably implicate the underlying substantive merits, but that's okay. That's to be expected. And what matters is not whether or not the plaintiff suing uses the label ultra vires or says that something's illegal. What matters is whether that is borne out by the allegations and ultimately by the evidence. And so here, the city argues that GA 38 is unlawful because it relies on the governor's authority to suspend statutes and that the statutes suspended fall outside the Disaster Act. There's two reasons why that allegation is not meritorious and why it's insufficient to overcome sovereign immunity, or in the context of the temporary injunction application, why it's not sufficient to demonstrate likelihood of success on the merits. And so there's 2 points on this. One is that no laws need to be suspended for GA 38's mask mandate. And then 2, that the city's interpretation of the Disaster Act has already been rejected by the 8th Court of Appeals as being overly narrow. And so even if the suspension power were invoked or necessary, it wouldn't matter because it would be authorized by the Disaster Act. And just to reemphasize that the suspension power is only invoked to the extent necessary. And for the reasons I already explained at the outset of the presentation, the movement of persons and occupancy of premises is fully sufficient to authorize GA 38's ban on mask mandates. And I think we've heard hints that, well, the GA 38 can't be valid because it doesn't sufficiently combat the pandemic. In our policy judgment, the governor got it wrong. And I'll just say briefly that the Disaster Act contemplates both sides of the equation, both the measures to combat the pandemic, but also measures that involve the rehabilitation of persons and property affected as we attempt to move beyond the disaster. And the Texas Supreme Court has recognized that the governor can be motivated by different things when issuing executive orders. It's not merely a desire to alleviate the threat of the pandemic. It's also other important policy goals, such as the right of an individual to choose to make health decisions for themselves and that of their children. One really important distinction that I think is often overlooked is the difference between preemption and suspension. And preemption is just the general idea that if there's a specific state statute that says you cannot do X, Y, Z, then that preempts a local ordinance to the contrary, and it does so without needing to suspend anything. So, if there's an ordinance of a home rule city, such as the city of El Paso, that attempts to regulate a subject matter that's preempted by a state statute, then that ordinance is unenforceable to the extent it conflicts with the state statute. And so I think the city of El Paso, much like the city of Austin at one point, had some sort of bag ban, that plastic bags couldn't be used by grocery stores. And then the state issued or passed a law that basically overrode that policy judgment. And that's an example of preemption. It wasn't that a statute was suspended, it was that it was preempted because state trumps local. And so as the El Paso Court of Appeals put it about, I think, 9 or 10 months ago, state law will eclipse inconsistent local law. And so here, it's not that the health commissioner has no authority, certainly he does, but that his authority is constrained to the extent at which there's a direct conflict with state law. And GA 38 is a state law. It's given force and effect of law. And so preemption is what operates here, and suspension is just sort of the belt and suspenders, and the belt of preemption is more than sufficient to support GA 38. And this is the El Paso Court of Appeals opined recently about why this applies in the context of the Disaster Act, that if the disaster was something like a hurricane, and the governor wanted people to evacuate one direction, but the local county judge thought better to go the opposite direction, then there would be a conflict. And whatever sort of disaster you can imagine, whether it's an earthquake or toxic chemicals, there would be that opportunity for reasonable officials to disagree about what ought to be done. And in the face of such disagreement, then the governor is the tie, wins the tie and gets to make the decision. And that's how preemption works. If the state makes a policy decision and there's a local official who wants to make the opposite policy decision in the face of a direct conflict, the state preempts the local. And that applies equally with the context of the Disaster Act.
So Mr. Dower, with respect to that specific example you brought up,
yeah,
if the governor said, don't evacuate, and the local official said, or the governor said, don't evacuate unless you think it's the best thing for you to do, given your personal thoughts and beliefs. And then the local official said, you must evacuate because there's a danger presented by this this coming hurricane or whatever the disaster was. Are you saying that in that case, the governor's order would control?
Yes.
The governor's order, don't evacuate, don't do anything, just do what you'd like?
Yes, Your Honor. And maybe the governor in that scenario determined that if everyone tried to evacuate, everyone would be stuck in cars at the time the hurricane hit. And so we don't want everyone to try to flee at the same time. I know I'm responding to a hypothetical with a hypothetical, but But yes, Your Honor, you're directly correct that in the face of that scenario, the governor's order would control.
So as Mr. Arambula was arguing, then the governor's, according to your arguments, the governor's authority is unfettered and he can do whatever he wants, because you give a hypothetical explanation as to why he might say not to evacuate, but there could be a different hypothetical reason to not evacuate just because he wants to be contrary to the local official. And if that were his reason, according to your argument, that's good enough. Is that correct?
Well, Your Honor, I'm not going to agree to a hypothetical where the governor is deliberately leaving people in harm's way just to thumb his nose at a local official. But what I would say, Your Honor, is that the system that the Texas legislature put in place gives the governor ability to make those decisions. But I would say that there are limits. It's not unlimited. It's limited by the power given to him in the Disaster Act and by constitutional limitations, so that if he acted in some way that violated a constitutional right, that would be, of course, a limit in his authority. But here, that's not the case.
So you agree there are limits to his authority to act?
Absolutely, yes, unequivocally, yes, there are limits.
And so I pose that hypothetical because it seems very similar to the issue we have before us, where the governor is saying, use masks if you'd like, even though there's scientific evidence that supports the use of masks, even though the governor himself has previously imposed mask mandates. The governor saying, well, I'll leave that up to each of you individually to make that decision. And if a county official wants to make a different decision, I'm going to block them from doing that. How is that different?
Well, Your Honor, I think that the governor has made a decision to prioritize people's choice about making decisions about their own health and the health of their children, and has apparently put more weight on that scale than the local health official. And we heard, but the local health officials make those same sorts of trade-offs. We could have a mandate that, well, we couldn't under GA38, but one could imagine a mandate that requires people to wear only N95 masks, because a handkerchief or a paper mask is pretty ineffective at controlling, the spread of the pandemic. But that was a decision that wasn't made. And so I think.
But that's not. I apologize, but that's not what the governor is concerned with here. He's saying, I don't want any mask to be worn at all. He's not saying, well, I don't think your mandate is effective because it allows for different types of masks that we believe are ineffective to be used. He's saying, I don't want masks to be mandated at all, even if you were to mandate N95s or medical, masks that are medically accepted to stem the spread of the virus.
Well, Your Honor, you're correct on he prohibits mandates. I would not agree with what Your Honor initially indicated, where he doesn't want people to wear masks. I think the executive order is quite clear that he does encourage people to wear masks whenever it's not feasible to maintain social distancing. And so, but you're right that he would let individuals and parents make that decision for themselves and not have the government mandated. And so that you're right, there is a difference of opinion on that policy decision. And what I would just submit to the court is that the Texas legislature has given the governor authority to make that decision for the state in the event of a conflict.
So one concern I have, Dr. Ocaranza was testifying about the purpose of a mask. One purpose of a mask was to protect the mask wearer from infection, from the virus. And of course, one could argue, well, that's up to each individual whether or not they want to wear that mask and protect themselves. And that's an individual decision. But he also testified that the other purpose of the mask was to protect other people in the community from that particular person spreading the COVID virus to other individuals in the community. So.
No, I hear you, Your Honor. And I guess what I would say to that is that this case is not about whether people should wear masks or whether the government should make them do it. It's the question is whether or not the government officials have the legal authority to decide what the government's position on such questions will be, and specifically whether or not the city of El Paso's local health official who we heard testify can use his judgment when that judgment directly conflicts with an executive order issued by the governor. And so it's a strictly legal question, as I said from the outset, about who gets to decide in the event of a conflict. And that's the decision before the court, is whether or not the governor has legal authority to make that decision. And we submit, based on the arguments and the law that I've put out today, that the governor does have that authority.
So let me ask you, and I know you said that he's not necessarily suspending, or his executive order doesn't necessarily suspend any statute or whatnot, but going back to Texas Government Code 418.016A, where it says the governor may suspend the provisions of any regulatory statute prescribing the procedure for conduct of state business or the orders or rules of a state agency if strict compliance with the provisions, orders, or rules would in any way prevent, hinder, or delay necessary action in coping with a disaster. How does this mask mandate ordered by Dr. Ocaranza or instituted by Dr. Ocaranza in any way prevent, hinder, or delay necessary action in coping with a disaster?
Well, I think, Your Honor, that it would operate within the general sort of policy judgment about whether or not a local health authority has gone too far and it hinders the response to the disaster in the sense of that it violates people's rights to make choices about themselves. And so I guess for that, I would refer back to the Texas Supreme Court's decision in the Anti-Defamation League case.
So the governor, by entering this order, his concern is to allow people to make their own health choices. Is that correct?
Yes, Your Honor.
Okay, thank you.
You're welcome, and thank you for these excellent questions. I don't want to touch too much on suspension because, frankly, I don't think it's necessary, and I think the preemption is what really carries the day and what really matters. But briefly, it's interesting that the argument they're making about how to interpret the Disaster Act has been squarely addressed and foreclosed by the very appellate court above this honorable court, the Eighth Court of Appeals. The Eighth Court of Appeals held that a regulatory statute means that, a statute that controls or supervises, that this is a broad statute that means to control or supervise by rules and regulations. So any statute that supervises or controls, and then as far as state business, they're not saying it's state business means like a state agency, but just the business of the state. That it doesn't just mean the activities of state agencies and actors, but includes things that occur on the local level, because the state can use the county as its agent in the state's function and duties. And so it is the Eighth Court of Appeals has interpreted this language as much broader than my friend on the other side would have it. And so since that's the controlling authority above this court, I would submit that this question about how to interpret these words has already been decided. But again, really preemption is what matters here. The suspension is a belt and suspenders where the suspenders aren't needed. And since GA 38 specifically says only to the extent necessary, it's not necessary.
I'm sorry, I apologize.
Oh, that's fine.
Interrupting, but with respect to what the Eighth Court decided, that was a very different issue, wasn't it? Because that was dealing with an order that had actually closed down several businesses and whatnot, as opposed to leaving businesses open, but just allowing the county to implement these mandates that will help stop or slow down the spread of COVID-19.
I think factually it's different, Your Honor, but legally it's not. Because when the Eighth Court of Appeals issues a published opinion that says, here's how you should define these terms, It doesn't matter whether that case arose from a business closure or a mask mandate. What matters is we have a published opinion from the appellate court saying, here's what these terms mean. And that's the definition that controls.
But the factual, the underlying factual situation in the previous case is very important, because the argument that the county or the city or whoever it may be, Dr. Ocaranza is improperly trying to I guess, overstep their bounds and control ingress and egress to various facilities. It's not the same. I mean, when you're closing down the business, yes, you are controlling ingress and egress to these various businesses or facilities or whatever it may be. When you're asking someone to wear a mask, you are not closing down ingress or egress to these various facilities. You are simply saying that in order to enter these facilities, you must wear a mask. And that is a personal choice that each person can make, whether or not they want to enter that particular facility. And if they choose not to, they don't have to. But if they choose to enter the facility, then they would wear a mask. So they're not saying you can't go in. They're just saying these are the circumstances under which you may go in. And they're doing that based on, based on the fact that these people may be spreading COVID-19 without knowing that they are doing so. And so you don't want the people that are in that building or that facility exposed to that unnecessarily if you can control it.
I hear what Your Honor is saying, but that is still an exercise of control over movement into the premises and occupancy of the premises. Because if you're going to enforce a mask mandate, that means you will not allow someone to move into the premises without a mask. And if you're going to, if someone's not wearing a mask in the premises, then they will be forced to leave. And we have seen this in other jurisdictions. There was a commissioner of the Dallas Commissioner's Court who was removed from a commissioner hearing by the bailiff. And I mean, that's how a mandate is ultimately enforced. You force someone to leave if they're not complying, which is an exercise of control of occupancy. And so I don't see that as being a meaningful distinction, since it ultimately comes down to control of movement in the premises and occupancy of the premises. And Your Honor, I'm going to move on now to just talk briefly about irreparable harm. The city has to show an injury to the city. The injury cannot rest its injury on something suffered by the local population. The line of cases that allow a state entity or a political subdivision to rest its injury on a general injury suffered by the population writ large doesn't apply to political subdivisions. And what we haven't seen evidence of is an injury experienced by the city as an entity, as opposed to the public at large in the city. But even talking about the public at large, what we're really talking about here is the difference between people being encouraged to wear masks and people being required to wear masks. And we heard the testimony that Delta started in week 24. So I added week 24. Excuse me, actually it should be one back. But so it should be sort of here, but you'll notice that there's not a sharp uptick when the Delta variant arrived. It's actually pretty level. It's nowhere near as precipitous as the drop that we experienced in around February. And
you would agree that that's probably or maybe due to the fact that it was just starting to spread, and so it takes time before it spreads?
Yes, Your Honor, absolutely. But my point is that in order to demonstrate an irreparable harm, they have to show that the difference between a mask mandate and a mask encouragement, or a mask, like a public awareness campaign, that difference is the difference that causes the irreparable harm. And just looking at the data that Dr. Ocaranza showed us earlier, we just haven't seen such a dramatic spike such that the difference between the two is an irreparable harm, particularly as people become more aware of the risk of the Delta variant, things aren't the way they were 3 months ago, that people would then choose to wear masks on their own accord.
Mr. Dower, so how dramatic does the spike have to be for it to be sufficient?
Well, that's a great question, Your Honor. And what I would say is that it's the plaintiff's burden to demonstrate an irreparable harm. And I would say that they have not done so. And they have not shown that the difference between a mandate and encouragement makes that difference. That a mask encouragement or a public awareness campaign or encouraging social distancing would be insufficient in itself to address the injury. And so in conclusion, Your Honor, we would just ask the court to grant the plea to the jurisdiction based on standing and sovereign immunity, and to deny the city's application for temporary injunction. And to grant the temporary injunction is to decide that the court has jurisdiction to do so. And so if the court is inclined to grant the temporary injunction, we would just ask that the court issue an order that goes ahead and denies the plea so that the issues can go up together, since they're so intertwined, as we saw in this presentation. And I thank the court for the court's patience and for the excellent questions that the court asked.
Thank you, Mr. Dower. Mr. Arambula?
Thank you, Your Honor. I'll just address a few of the points here that I think probably need to be clarified. I think first and foremost, this contention that somehow the governor isn't attempting to actually suspend statutes is on its face disprovable. GA 38, and I'm looking at section 2, is it 2A? And I'm reading directly from it. It says, I hereby suspend section 81.082 F1 of the Texas Health and Safety Code to the extent necessary to ensure that no governmental entity can compel, and it goes on. But the whole point is this, whether it's a partial or a full suspension, that's exactly what he's doing. That's what the text of GA 38 and every prior executive order has done. It's suspended statutes. That's literally what it's doing. In this case, whatever it is not a case of preemption, because as we argued in our original petition, Dr. O's authority to engage in the conduct that's required by state statutes is at issue. Here in this particular case, we're talking about Health and Safety Code chapters 81 and 121 that spell out the authority, the duties, and the requirements of local health authorities. So this isn't about preemption. The governor is not suspending an ordinance here. We don't even cite an ordinance in our petition. There's none there. So there's no preemption. What the governor is doing is he's suspending state statutes. And that's on the face of all the pleadings that we have, and on GA 38 on its very face. Now, as to this issue about whether or not, I think council was referring to City of El Paso, or I'm sorry, state versus County of El Paso. When you read that decision, it very specifically does so on very narrow grounds. And the reason I would assume that council and the governor are putting forward the idea that is binding on this court is a very specific one. What happened in that particular case is Judge Samaniego issued an order that could arguably be said, or was actually now the Eighth Court of Appeals has found, that controls ingress and egress. The reason that was an issue in that case is that the Texas Disaster Act actually has a provision that gives both the authority to both the governor and the local disaster authority to control ingress and egress. So to the extent that that case actually decided any issue, it decided who actually preempts, and they decided that the governor is. But that's exactly why we keep hearing about ingress and egress. Ingress and egress, and I responded to that in our petition, but I will tell you this, Your Honor. There are 18 statutes that refer to ingress and egress in Texas law. Not one of them even remotely has any language that can be rationally considered related to masks. Nothing. And there's no case law that contains anything even remotely resembling some kind of connection between ingress and egress and face masks. There just isn't. It doesn't exist. I mean, I know it's hard. I looked for quite some time, but there's nothing. And here, what we're getting is an argument that attempts to fit that square peg into the round hole of this situation. Because here, what we're saying is ultimately that the governor suspended Dr. Ocarranza's authority to engage in his state mandated authorities and state authorized authorities in order to actually empower, I guess, the enforcement of GA 38. That's what this is about. That's why I think the argument here is that somehow that the El Paso County case is binding. It's not. And the 8th Court of Appeals literally went out of their way to point out that it is only deciding that case on those narrow facts. So if the court finds that the facts and the law in that case are not applicable here, then it's not binding in any form or fashion. And with respect to these Texas Supreme Court order that counsel was referring to, that's an order. And I think, as this court knows, every temporary injunction and every other action going on around the state that results in some kind of action barring the governor from enforcing his the mask mandate or GA 38 or any aspect thereof, each case is unique. Each jurisdiction deserves the right to put their own case forward. That's why when it comes down to the issue of whether it's binding or, arguably here, it might be persuasive, but it certainly isn't binding. It's not a published opinion, and it's a case that's still pending appeal. So there's absolutely no binding authority there either. The question here for the court is actually a very new one. The question here for the court is, does the governor actually have the authority to suspend statutes the way he does? That's the question that's going to be asked of this court down the road when we're having a discussion at the jury trial through evidence and exhibits and case law and statutes about whether or not he's actually doing so. And no amount of I guess, argument is going to change the fact that at the end of the day, the statute, the governor's own order says it suspends statutes. That the Texas Constitution says that the governor is not entitled to do so. He's the state's executive. Only the legislature can do that. And another constitutional article that states that, in fact, that cannot be delegated from the legislature to either other branch. Very straightforward. And then at the end of the day, I think what the court also hasn't heard is how there is any argument about the fact, and here we're talking about a long line of Supreme Court precedent from this state stating that, in fact, the suspension statute says it means what it says. Nobody but the legislature can suspend statutes, but that is what's happened here repeatedly. And, at the end of the day, Dr. O's actions here are in support of the city. He is a contract employee of the city who has to carry out independent duties so that he can actually do what he's supposed to do, which is, by the way, also statutorily required, safeguard the health of the people within the community. That's literally what he's obligated to do. He's literally obligated to take action in support of the health of the individuals in this community. And here, when we're talking about numbers, there is absolutely no common sense, and I would arguably say medical reason, that the doctor has to wait until the same situation that happened here back in November when we had FEMA trailers happen again. Are we really expected to say to the community that we have to wait until this is so bad that we have to ask the federal government for FEMA trailers to store bodies because we have no space in morgues or in the hospitals in order to take care of it? Of course not. That's a question that should be made by a local health authority, because that individual is the only one who, with eyes on the ground, who can say, hey, I need this or I need that, or this particular act is warranted. And I think what's obvious from Dr. Ocarranza's testimony is that he's been trying to do this with his hands tied behind his back by the governor's reading of a statute that makes it so broad that it essentially just makes it so that he has unlimited power as long as he claims that that there is a current disaster going on. At the end of the day, that's it. In this court, and the reason that both the plea to the jurisdiction should be denied, and the reason that the city's temporary injunction should be granted are for both the same reasons. Number one, the governor's reading of the Texas Disaster Act is ultra vires. He has absolutely no right to read it in the way he does. I mean, it doesn't even comply with the act, just a plain reading of it. Secondly, there is irreparable injury here Because here we have a local healthcare authority who knows what's happening on the ground, who can't do his job because the governor has made the decision that he knows better than the local health authority what particular measures are done, which, as the court was asking a while ago, he would be authorized to do, but only if that is the actual authority that was granted to him by the legislature. And what we are asking this court to decide at a trial, at a bench trial, is actually that question. Does he have that authority? And then as far as irreparable injury goes, Your Honor, here, I'll paraphrase what counsel said. It's not like the governor is actually deliberately leaving people in harm's way, but that is the end result. And it's the end result because his reading of the Texas Disaster Act does not permit a local health authority to take actions consistent with his own medical observations and his own ability to decide what would be best. And by the way, that's not me simply saying that that's actually what would be right. When read in its entirety, the Texas Disaster Act is meant to be a cooperative agreement. It's meant to allow the governor to have overall view of what's happening. So if there was a hurricane, you know what? If the governor's in Austin, the local health authority should be able to say, you know what, get out, before calling the governor for permission to say, may I actually evacuate? Well, of course it can't be that. If there's a fire and people need to be left, need to be ordered out of town, we don't have time. A local health authority or disaster manager doesn't have the time to actually pick up the phone and wait till the governor is found. They need the independent authority. And by the way, that's exactly what the Texas Disaster Act does. It vests them with authority to engage in conduct that needs to be addressed immediately. Now, the fact that this case, that the pandemic has been raging and going on for 2 years notwithstanding, the very terms of the Texas Disaster Act are meant to address disasters no matter what they are. But what they're also meant to do is provide authority, and once again, cooperative authority within limited circumstances in order to provide local authorities the ability to do so. That's what this case is about. It's about statutory interpretation. It's about the governor clearly and repeatedly ignoring the limitations placed on him by the Texas Disaster Act, case law, and the very statutes he purports to suspend. That's what it is. He is impliedly reading the Texas Disaster Act to permit him to suspend statutes which the Texas Disaster Act and other case law explicitly states he cannot do. That, at the end of the day, is what this case is about. We ask this court to deny the plea to the jurisdiction. We ask this court to grant the city's temporary injunction and set a date for a bench trial at its earliest convenience, along with any type of procedural schedule the court sees fit. Thank you, Your Honor.
Thank you both for your thorough and professional presentations. It's very helpful. Thank you. With respect to your final hearing, your bench trial, what time frame are the parties looking at?
If the court decides that it would be appropriate, Your Honor, we can do a month to a month and a half. If the court decides to grant our temporary injunction and deny the plea to the jurisdiction, we'd ask that it be set in a month. Obviously, most of the questions here would be our legal questions. We would have a few, at tops, maybe 2 to 3 witnesses. Obviously, that would be a schedule if the court decides that, in fact, that would be appropriate.
And Mr. Dower?
Well, Your Honor, once these 2 orders are issued denying the plea and granting the temporary injunction, the case is going to go up on appeal, at which point the Texas Civil Practice and Remedies Code institutes an automatic stay of all proceedings. And this is always an awkward thing to say because I have the utmost respect for the honorable court, but the case is at that point going to go up on appeal, and in the trial court, everything's going to be frozen until we get a question on the legal issues. So I'm not too wedded to any particular schedule, because unless we kick it really far out, it's probably going to be moot anyways, because the appellate courts will tell us who is correct here, and then we'll all proceed according to that. So I'm not opposed to the schedule that my friend on the other side suggests. But it's just, as a practical matter, it probably won't matter.
Right, and that may be the case, Your Honor, but I think the salient point here is simply the court sets it, and then if and when the Attorney General's office files their appeal, then we, just like everything else, we take it procedurally as it comes by.
Right. And so I'm not opposed. I'm not opposed to his suggestions, I guess, the more direct answer.
And if I grant the temporary injunction, I am required to set it for a final hearing.
Right.
So based on that, that's why I was asking regarding that particular date, and if there were any particular dates you were looking at. Mr. Arambula, have you prepared a proposed order for the court?
We do, Your Honor. We have a proposed order. And just as a reminder, Your Honor, since the temporary injunction actually expires today, the court would have to make a ruling on it today. I mean, obviously, the court is not obligated to simply make a verbal pronouncement on that, but we certainly have an order. I know that the Attorney General's office has submitted one. We will submit one to the court with a CC to Mr. Dower so that they can have a copy of it. We'll just await the court's ruling if and when it decides not only makes a decision, but what the scope of the decision.
And Your Honor, I'll maybe slightly cynical, but I'll go ahead and submit a proposed order denying the plea as well, just in case Your Honor wants to go that route.
Yes, sir, Mr. Dower. And so with respect to the plea to the jurisdiction, as I had indicated earlier, I don't think that it was properly set before the court for today. And then given the fact that I did give you the option of allowing the city to reply and giving them time to file a formal response, but you did not want to exercise that option, it's my position that is not properly before the court because of your unwillingness to continue it for that matter. To the extent that it was presented to me here and the appellate court may consider it timely filed, given that it was before the hearing, and a plea to the jurisdiction can be raised before the hearing, and that there's really no limitation there. To that extent, I would deny your request. So I would deny it based on both of these reasons. One, that it was not timely filed and timely brought to the court's attention and with sufficient time for the city to respond. And then two, just denying that relief. With respect to the injunction, I'm going to take that under advisement. What I'm going to do is I'm going to go ahead and recess for this afternoon, but I'm going to have us come back today at 3:30. And by that time, I'm assuming each of you will have submitted your proposed orders, and I will review those. And when we come back at 3:30, I'll go ahead and give you my decision on the temporary injunction.
Yes, Your Honor.
Is there anything else you need to take up at this moment?
No, Your Honor, thank you.
Okay, and just so that the parties know, we will be using the same Zoom link from this morning. So you can just get back on that same link.
Yes, Your Honor.
Okay, so 3:30, and just to be clear, Mr. Dower and Mr. Abramson, you're probably in Central's time, right? So that's 4:30 for you.
Appreciate the clarification, Your Honor.
And I'm sure you knew that, but just to be clear, you never know. That the minute I don't say it is when someone says, "Oh, I thought it was something else."
I've showed up an hour early or 2 hours early because I got the direction backwards. So I understand and I appreciate it.
All right. And with that said, thank you, everybody. We are adjourned and in recess until 3:30.
Thank you, Your Honor.
Thank you.